Morning.
Good morning.
Good morning, everyone.
Good morning.
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 Good morning.
Good morning.
Okay, I'll do the register and then we can get started. You could just give me the names, please.
Palacios, Tadashi Palacios.
Mhm,
Nikita Isaacs,
mhm,
Marsha Lightborn,
mhm.
Janice McDonald.
Mhm.
Paul Farquharson.
Mhm. Mhm.
Siobhan Linden.
Thank you.
Richard Roll,
Mhm. That's it.
Jamia Joseph,
Okay.
Sarah DeVoe,
Say it again. What's the name?
Sarah DeVoe,
Okay. Anyone else? I have everyone. 1, 2, 3, 4, 5, 6, 7. Okay. 1, 2, 3. Okay. I'm missing one. Okay. Okay, see. Smith. Okay, Smith, your thing isn't working, I guess. Okay. Okay. Good morning, everyone. Again, and I hope you had a chance to review our little session from last week and we got our homework done. Yes.
Yes, with some difficulty.
Oh, boy. Okay, so who's the president of the Industrial Tribunal? Is it still the same?
Yes, it's still the same.
Okay.
Indira Demerit.
Okay, vice president, are they still the same?
Yes.
Okay. You only have 2?
And an acting vice president, Ingrid Cooper Brooks.
Okay, so Helen Jones is still there.
Yes, ma'am.
yeah,
Okay. Okay. Did we ask about the secretary or?
Yes. The lady who spoke with me from the tribunal yesterday, she seemed like she didn't want to give much information, but she said right now those 2 posts are vacant.
Okay then. Okay.
And she was trying to give me the name of the last secretary, but she
Okay.
said she couldn't remember the lady's name at that time, and that I didn't find that information on the website either.
Okay then. Okay. So that's all we could do with that one. Now, just to recap, we know what a quasi-judicial process is. What's the standard of proof?
It's on the balance probabilities, which is a lesser standard.
Okay. In terms of doing what? What's the lesser standard in terms of what?
The standard of proof.
So that's proving the case then against somebody else.
Yes.
When did we establish our Industrial Relations Board?
mm, 1970.
Okay, and how it was enacted under which legislation?
It's active under the Thingamere legislation.
And Dash,
Huh? What did she say? Sorry.
Industrial Relations Act.
Excellent. Okay, and what's the jurisdiction of the tribunal?
Here's trades dispute by the labor board.
Referred by the labor board.
Or,
Or
Or
by the parties
directly.
themselves.
right. Now, we have, how is the industrial tribunal composed?
President and 2 vice president. Sorry, a president. Yes.
And 2 vice presidents?
Yes.
Okay. And in accordance with the powers, what they have, what powers do they have? Just give me 2.
To reinstate.
Mhm. And
They can remit a dispute to the parties for further consideration. Or
okay. And how is an application started at the industrial tribunal?
with an originating application.
What that application is? What we call
Form
that
A.
over there?
Form
Form
A.
A. Okay. Now, what about when I'm filing a defense? Which application will I use?
Form C.
Defense?
Notice to appear.
That'll be
No,
Form F.
Be Form E.
Form E.
Form E.
Form
Form
E.
E.
Yeah.
Form E. We'll file a Form E. Now, what happens if the parties don't comply with the rules or time limits? What can happen?
The case, they can be barred from participating.
So I've not complied with the time limits given or something that they asked, requested of me. What may happen?
It may be striked out.
Struck out.
What tells me it could be struck out? Where I find that?
On page 33.
No. Where I can find that in the act or the rules or something? Where I can find it?
Section 7.
Say it again.
Section 7.7.
Of what?
Rule
The
16.
the Industrial Tribunal rules.
You're right. So it's 7.7 of the Industrial Tribunal rules. Yes. Now, how can I withdraw?
Notice of withdrawal, Form K.
Excellent. So we know the notice of withdrawal, Form K. And when I need extra time, can I extend my time?
Yes. Yes, you
What-
can.
By what?
Form L.
Okay, excellent. And can the tribunal combine proceedings?
Yes, they can.
And what form is that?
Form N.
Okay. All right, so that's probably a recap. Now, how do we serve notices on parties or companies or the like? How would we serve notice? What rule guides us on serving notices?
They serve at a place of business.
Rule, which rule?
Rule 18.
Yes, and we will serve it where?
Is address or place of business.
Right, and where this address will be found?
Okay.
Form B.
Where you find your address to serve you? Didn't you have to provide this somewhere?
Right, the notice of defend or what is it called?
So The applicant provides this address where?
On Form A, the application
Right,
is
On Form A.
right. And then where does the
Respondent,
defendant provide his own?
Form C.
The respondent, what we'll do? We will find that.
on Form D, eh?
Form E. Form E.
Which one?
E.
No. What we have before Form E?
Form D.
Yes, Form D. Form D tells us the notice of appearance is filed, where the respondents provide the full name and address. Yes?
Yes.
Okay. Okay, so now we move on to Module 3. Module 2, you have a good understanding?
Yes, with constant reading.
Good.
For the most part, it's just
I
about
sent you
information.
some cases last night for Module 3, so you'll have some reading you can, to reinforce the module thereafter. Okay? And some of it is an overview, so it gives you some further clarity on the subject matter here. In Module 3, we're dealing with the employer-employee contract. And after this chapter, we should understand the elements of a valid contract, gain knowledge on the parties to a contract, understand the legal implications for a breach of contract, develop knowledge and understanding of the formation and characteristics of the employer-employee contract, and create an awareness of the key terms and conditions in the employer-employee contract and the significance of such terms and conditions. Who will help us this morning with beginning our reading? So you only have to read from what is a contract to number 6 of the general legal principles on page 40.
I'll go.
Thank you.
What is a contract? A contract is an agreement between two or more persons or entities that is enforceable by law, provided certain essential elements exist in the formation of that agreement. Essential elements of a valid contract: 1, offer; 2, acceptance; 3, consideration; 4, intention to create legal relations; 5, capacity; 6, certainty of terms.
Okay, so please pay a special attention to the valid contract, the essential elements of a valid contract. Okay, that's important because it always comes back to that. Go ahead.
In addition to the essential elements of a valid contract, one must consider the following areas as well. 1, formation determines how and when the contract is created. 2, validity. The contract must be valid to be enforceable by law. 3, terms. The parties and provisions of the contract is necessary to determine the nature, extent, duties, responsibilities, obligations, and potential legal liabilities. 4, discharge. Addresses how the contract may be terminated. 5, remedies. Outlines the legal redress for breach or unintended termination of a contract. 6, limitation. Determines when action can be taken on the contract. 7, privity. A contract is only enforceable by the parties to the contract.
Okay, so we've gone over what is a contract. So we should be well aware of the basics, where we have a contract between two persons or entities that is enforceable by law, provided that the essential elements exist in the formation of that contract. So the essential elements are, we had to have an offer, there had to be acceptance by the parties to whom the offer was made. There must be consideration after acceptance. So consideration could be in the form of money. There should be an intention to create legal relations, and this would happen where most of the elements The first three elements may not be clear, but there should be an intention somewhere if consideration wasn't given. You have to be, you must have capacity, so you must be of sound mind and legal age, and there must be certainty of the terms. So there should be terms that are certain in there. So we know what the terms are. There should be the parties. What are the provisions? That's the nature of the contract, the extent to which the contract, the terms of the contract are, what duties are assigned. So we find that in lease agreements, we have what are the duties of the tenant, what are the duties of the landlord, what legal implications there may be for breach of such duties, and your obligations under a lease. In considering the essential elements, we must also consider formation. So how and when it's created. So the date on which it was created, how we created the contract. Validity, the contract must be enforceable by law. So it can't be an illegal contract. You can't contract me to do something that's contrary to the law. So it must be valid. Again, the terms, which is the parties and provisions of the contract, the nature, extent, duties, responsibilities, obligations, and the legal liabilities for breach. Discharge, it deals with how the contract will be terminated. So once you fulfill your obligations, there should be some discharge in it to say after a year, this contract is no more. So it can be renewed upon successful completion or consideration of a new year based on your performance, or a lease can be renewed once the tenant has given the landlord 3 months notice that they intend to renew the lease. So if you didn't give me notice, I have no obligation to renew your lease. Remedies, it outlines the legal redress for breach or unintended termination. So if you didn't follow the lease agreement, if you breach this lease agreement before the period is ended, we can enforce the balance of the contract. We may have some enforcement clauses. If you breach an employment contract, we may have enforcement. So there's remedies that may be outlined in the contract for breaching the agreement. If you divulge secrets, confidentiality, there may be some legal ramifications for you. The limitation, it determines when action. So limitation on contracts. So on contracts of, just say you owe the bank, and for instance, there's a limitation period as to when they can recover their funds from you if they've not enforced the contract over a period of, I think they have up until 6 or 7 years. There's a limitation period. So we have the Limitation Act. Personal injuries, you have up to 3 years. Where there's a debt, you have a year. So you can enforce contracts up to that point. So if I owe Scotia Bank, I've not paid them for almost 6 years, and they decide to come to me 6 years and a day later. I'm just going to confirm the time exactly. When you take me to court, you have been statute barred from enforcing that I owe you the money. So by law, you can't, you can no longer take me to court unless I would have done something to restart the time that you had not enforced your contract. Privity is a contract where it's only enforceable by the parties to the contract. So if you and I have a contract, a third party cannot enforce your rights under the contract. It's only between the two parties involved. And of course, there are exceptions to these rules. We'll find that out as we go along, because nothing is just that plain and simple in law. You would always have some exceptions. Any questions? Okay, let's continue.
Offer. An offer is a statement of terms on which the person making the offer, the offerer, is willing to be bound. Parties to an offer. 1, offeror, which is the person making the offer. 2, offeree, person to whom an offer is made. General legal principles regarding an offer. 1, an offer is not an invitation to treat. An invitation to treat is an indication that a person is willing to enter into negotiation for the purchase or sale of an item, but is not an indication that he is willing to be bound by terms of the invitation. Examples of invitations to treat are items on display on a shelf or in a shop window, catalogs, prospectuses, etc. Additionally, giving information or making a declaration of intention is merely advising and is not considered an offer in legal terms.
Okay, so we have the invitation to treat is not an offer. So when I'm advertising, if I'm advertising in the newspaper, I've only offered something and it's only an invitation for you to now, you can purchase or you may not purchase. I'm not obligated by the advertisement that you must have the item. Likewise, in the store, I can have items displayed on the store shelves, and based on what I have there, it's not a contract. It's more or less. It's not an offer in terms of a contract. It's just an invitation for you to, it's an invitation of you now saying, I have these items, but we have not entered into any formal agreement until we reach to the point where this offer is now accepted and consideration is now given. You've now taken the item out of the store. So where it is on the shelf, I may say there's some other term that goes along with it because I've only invited you to look at the item more or less. So advertising is not considered an offer in some instances, and in the legal terms of you advertising, it's just an invitation to treat to the whole world. So it's not between any particular party, it's to the whole world. You have an invitation to treat. Okay, go ahead.
2, an offer can be revoked at any time. However, the revocation must be communicated to the offeree. The revocation can be made by the offerer himself or by an intermediary agent appointed by the offerer to communicate the revocation.
Okay, so when they revoke an offer, it must be communicated to the offeree, and the offeree is the person to whom an offer is made. The revocation can be done by the person who made the offer, the offerer, or it can be made by his agent or intermediary. It's important that communication is done before the acceptance. So that's important. We'll discover that later. Okay, go ahead.
3, an offer lapses after the period of time set or established within the offer. If no time has been set in the offer expires after a reasonable time, which often depends on how the offer was made and the nature of the offer.
So the offer lapses at the period set. So if I offer you, so just for instance, an agreement for sale, we may have a letter of intention where the parties have not formalized the agreement for sale, but the letter of intent says this offer or this letter of intention is subject to the parties formalizing an agreement within 14 or 21 days. Upon the expiration of that period, the offer is no longer valid. You cannot enforce the letter of intent any longer because now the time has lapsed. So again, offer expires within a reasonable time. If I've offered if I've offered something and you've not accepted within a reasonable time, and reasonable is relative to the period in which or the circumstances set. So reasonable time would be determined based on the environment and the setting. then it will now expire within that period. So it won't just last forever and ever. You can't come back to me a year later once an offer has been made to say, oh, I've just decided, because by then the offer may have changed, the price may have gone up, all of these circumstances may have changed. Go ahead.
4, if the offerer or offeree dies before the offer is accepted, the offer terminates when the other party is given notice of the death. 5, once an offer is rejected, it cannot be accepted. Rejection may be a simple no, decline of the offer, or a counter offer being made by the offeree.
Okay, so once I've offered you, I said, I'm selling my car. You're interested, I'm selling it for 5,000. Once you've come back to me to say, I can accept it, but I'm only willing to accept it if you can accept 4,500, you've rejected my offer. I don't have to accept what you offered, because now you're offering, you've counter offered. Therefore, my offer is no longer valid to you. Your acceptance is no good because you've rejected my offer with a counter offer. Go ahead.
6, an offer may be made to the world at large. Example, reward for finding or returning a lost item or doing a specific act.
So the offer made to the world at large is not the same as the invitation to treat. I'm offering a reward for you finding something. I've not offered that to anyone in particular. I'm offering that to the world. That's a difference with you advertising compared to you offering a reward, because you have now, what have you included in your offer?
You included a value?
Right, so that's what we call in the value in our essential elements.
That's the reward, eh?
And what we call in that, in the essential elements of the contract?
Offer.
Offer.
Consideration.
Yes, consideration. Okay. Okay, let's continue. Who's gonna continue for us?
I'll continue.
Thank you.
Learning objectives. Oh,
Okay,
sorry.
no, we
I'm sorry,
we
I'm on the wrong. Yeah, sorry, I'm
Yeah.
on the wrong page. Sorry. Acceptance. An acceptance is a final declaration or expression of an asset to the terms of an offer. General legal principles regarding acceptance. Acceptance may only take place while the offer is still open. Acceptance must be unequivocal. In other words, it must be absolute, unqualified, and clear in its expression. No conditions may be attached to the acceptance of an offer, and it cannot be considered a counteroffer.
Okay, so the acceptance is the final declaration or expression of assent to terms of the offer. So it is only accepted. It only can take place when the offer is open. So if the time is expired, it cannot take place. The offer is no longer open. And it must be unequivocal. So it must be absolute and unqualified. You can't put conditions to it, and you can't, your conditions may be that in the form of a counter offer. So we already say once you counter offer, what happens? The offer is what?
Close.
Null and void.
So you
No longer.
reject it. Yeah, so it's now rejected. Okay, go ahead.
Acceptance may be by conduct or words. Conduct may be the performance of a specific task or act required by the offerer. Example, the return of a lost item or reporting a missing person.
Okay, so I don't have to say to you, I've accepted it. My conduct may be sufficient to say I've accepted it. I've done what you've asked me to do. So now I should get what is the reward in this instance, or I've accepted by me starting working for you. So I may not have signed anything formal, but my acceptance is I've started working. You've offered a job. I've accepted by me starting to work, and you've not said to me, no, I have not offered. This job is not for you. So if you've allowed me to work, You can't come a week or two later saying, oh, no, I never had any, I've never formalized a contract with you because now I have done some things and you've not dismissed me from doing those things. So you as well have recognized the contract by my conduct. Go ahead.
Acceptance must be communicated to the offerer. No contract can exist unless and until the offerer is notified that the offer has been accepted. Two exceptions to this general rule. Where the offerer dispenses the rule that acceptance must be communicated to the offerer. And B, where the postal rule applies. The postal rule states that a letter of acceptance, which is properly addressed and stamped, is effective from the moment it is posted, provided that the parties to the offer contemplated or indicated the use of the post as a means of communicating the acceptance of the offer. It is important to note that the person claiming to have posted the acceptance letter must prove that he did so. Once he can prove this, there will be acceptance of the offer and a contract, provided that the other conditions exist, even if the letter fails to arrive at the appropriate or designated address. The postal rule does not apply to telegrams, but it does apply to telexes, faxes, and emails, although no decided cases have been made regarding the latter two modes of communication.
Okay, so acceptance must be communicated to the offerer. So no contract unless offerer.
Ms. Dorset, you're muted.
Sorry, I didn't realize it. So the acceptance must be communicated to the offerer, and no contract can exist unless and until the offer is informed or notified that the offer has been accepted. So what happens there? There are two exceptions to this rule, where the offer dispenses with the rule that acceptance must be communicated. So I may say, there's no need for you to formally accept or communicate to me. Once I've seen you do certain things or your conduct demonstrates that you've now accepted the offer. Or the postal rule, it only applies where the letter of acceptance is properly addressed and stamped is effective from the date it's posted. Now, you know, this could be a disadvantage to us in the Bahamas because of the slow period in which we receive mail. So what we'll have to do is to say, we dispense and we don't want you to return. No offers will be accepted by post. It only can be accepted by hand, or it can be accepted by email. That's the only way you will dispense with that, because then you may be waiting almost 3 or 4 weeks for an offer. And as at the date that it was given is the date when it's recognized. So as much as the offer may have closed on December 31st, you would have posted, you show your registered date of the posting of the letter, and I've not received it until January 31st. By then, I have had other parties who've come to me before you, or they may have, or I may have said nobody answered, and so now I've put it back out there and somebody else has come to me, but now the offer came in on January 31st. As at the day that the offer was posted, you, the acceptance was posted, you have to adhere to the acceptance of that. So if you would have given if you've given the item to someone else, I have some means of enforcing to say that you offered something, I've accepted, as I have the means of communication. I posted it as the date. I can prove that I posted it. So you can't now say I cannot have the item or it's no longer available to me, because as at the date you told me I had to respond, I've responded. So that's the postal rule. So it is important for you to say the means of communicating the acceptance in this instance, because if you use the postal rule, if you use the postal communication, then as at the day they post the acceptance is the day that you have to adhere to, and you may not get your acceptance in time.
Hello, Ms. Dorset. Hello.
Bueno,
Can you
bueno,
hear me? Hello?
Oh, we can hear you now.
When you stop hearing me, sorry.
In mid-sentence.
Okay. How mid the sentence was, how far back?
We were just saying about using your email if you, instead of under the acceptance and all that.
Okay. So
We not too long ago.
okay, good. So you who would have posted the letter have to prove that you posted it as at the date in order for you to enforce the acceptance. So you must, you know, when you're using the post, you must get it as you must register it. So you have to, you know, some people send you demand letters or by registered mail. As at the date that it's registered is when it went in there. You must, and once you would have accepted it, you now would have signed some document stating you received it. You know, the banks used to do that some time ago. They send you registered mail. You accept it at the date when you signed it. Likewise, when you accepted an offer, you use the registered mail, and at the date you posted it, you need to prove that you posted it. That's what you would use, the registered mail, to show you posted it as at that date. You won't just use a regular way of mailing it. You would use the registered post to show that you sent in, for proving that you sent your acceptance at a certain time. So even if it fails to arrive at the appropriate or designated address, in some instances, there'll be acceptance. If it didn't arrive at the date when it was supposed to get there, it will still be acceptance once you can prove that you've posted it as at the date that you were supposed to, ahead of the period for which the offer expires. Any questions?
So, Ms. Dorset, given the challenges with the postal system, whether the mail, well, even if the mail is registered, if an offerer, to cover themselves, should they specify that acceptance must be received by a certain date, or can they put some conditions so that a year from a date when somebody sends in, if their letter arrives a year later, but it proves that they sent it before the within the acceptance period?
Mm-hmm.
Let's say in the case of offer of employment, and they've
Mhm.
already hired somebody else because it's been a year, then like I'm thinking in the shoes of the employer, the offerer, how can they protect themselves from a surprise a year later, a piece of mail arrives and the person legitimately was the first claimant to that offer?
Right, so that's why we said in that instance, and in particular, we saying based on our postal system, we'll specify that in our offer. Acceptance must be made by a certain way of communicating, by hand or courier. You must send it by courier and send me the airway bill. So we could put all those conditions in there so that there's no, we don't have this issue, because, you know, a letter could be floating around for almost a year, right?
Mm-hmm.
So, and if you know that the letter's been floating around a year, you would follow up at some point if you've made if you've accepted something, you would say, well, you know, I haven't heard from you, let me know what's going on. And then you should be able to provide me with proof that you've accepted whatever it was I was offering in the meantime. But you waiting for almost a year, I don't know if that's reasonable time for you to say you were still waiting on me to continue to have this offer open for that period of time.
Right. And I'm even thinking in the case of a sale,
Mhm.
you know, buyer one mails in his acceptance of your offer to sell an item. You don't get it in time. You sell it to buyer B.
Right.
You have to go back to buyer B and take it back and give it to buyer A.
Okay, so now unless I will say, you know, you offered this, I've accepted it. You told me the means by which I could communicate acceptance. So therefore, if there was a faster period, a faster way for acceptance, then you should have communicated that to everyone. You know that some people may be applying by post, but you've accepted an offer, not given it reasonable time for you to receive post offers as well, acceptances as well. So you see the dilemma you may have in, say, in not specifying the conditions in which you will receive acceptance, because if you've left yourself open, so we advertising we've given you a contract of employment, and we have given you 7 days to respond to the contract of employment, and we've not specified how you should respond to us. So
You're off again, Ms. Dorset. Ms. Dorset, you're off again.
can you hear me?
Yes, ma'am.
Okay, sorry, my internet must be unstable today. I'm just moving over a little bit to see what happens. Okay, so if you don't specify within the if you don't specify to the person that you've made the offer to in the contract of employment, for example, the way you should communicate acceptance, you should provide me with this contract of employment signed. Read over the contract of employment, and it should be returned to us within 7 days. And you've not specified how it should be returned, and they used the postal way of sending it back. They send it by post. Then you should give a reasonable time for acceptance to take place. So, or you can reach out to the person to say, okay, your 7-day period is passed and I've not heard from you. Are you pursuing this any further? Because now you've not specified the manner in which you specify to avoid that pitfall.
Okay.
Ms. Dorset, you're gone again.
I think she disconnected this time.
It's pretty windy out. Maybe she really have unstable internet.
Sorry, I went off again. We can start again, please. Sorry, with consideration. I don't know what's going on today.
It's pretty windy.
Yeah, I don't know. And Cable Bahamas don't need no excuses.
Not at all. Consideration is anything, whether money or in kind, an act, given, promised, or done in exchange for something. With regard to a contract, each party to the contract undertakes to discharge a certain legal obligation under the contract, which has some value and is in exchange for some specific bargain or gain. However, it must be noted that the law relating to consideration does not apply to gifts, only bargains.
So we have what consideration is. What is consideration? Money or in kind. So that's an act, given, promised, or done in exchange for something. So you've asked me to take out the trash and you're gonna give me $2, or you're gonna give me extra time on the game, even with your children. You have made a bargain, eh? There's been an offer. I've accepted by doing what you asked me to do. So I'm expecting what's gonna happen next. I will get, once I've accepted, I should get what?
Money or my act in kind.
Right, I should get the consideration which you've promised. So that's a bargain. Bargain doesn't, this consideration, often accepted consideration does not apply to gifts. So if I'm gifting you with something that does not apply in this instance, eh?
Correct.
Okay, go ahead.
General legal principles regarding consideration. 1, past consideration is no consideration. It has no value under law. Past consideration is something already done or completed at the time a party to the offer promises to do it.
Okay, so you can't come today to give me something what I've already gotten. So if you've given me $10 yesterday, this has nothing to do with my offer today. So today I've offered you gave me $10 yesterday for something. You may have just gifted me or just said, take this $10. Today I have a article you want, a mouse or something of insignificant value. And $10 is a good price. I can now say, I'm offering to sell my mouse, and you'll say, well, I just give you $10 yesterday. Give me that mouse. I've already paid you. That's in the past. That's no consideration for the present. You can't use what has happened in the past to now show consideration for something that's in the present. Okay?
Okay.
Go ahead.
2, a promise to perform an existing duty or obligation to the promisee.
So if I am promising to do something that I am already obligated to do, give me an example. Can I provide that as consideration?
No.
Okay, so give me an example. Anyone?
If you make an offer for a specific salary range,
Mm-hmm.
and then you come back and say you promise to pay that exact same salary range, that's not a consideration because you've already promised that, or you've already offered that, made that in your offer.
Okay, so
An obligation to pay at a certain rate.
so this is before offer and acceptance. Let's say I'm already working.
Mhm.
What could happen in that instance? I'm working for you already. I'm employed to answer the telephones, to fix some coffee, to greet the guests. And now you've offered, you're offering something to say, I'm offering a job I'm giving somebody extra money. I'm paying a tea lady. So what I'm gonna say, instead of paying the tea lady, what you should do?
Let me make the tea instead.
Let me make the tea and give me that money.
Give you
What am I
the
gonna
money.
say? What that means?
You're already performing.
Yeah, so you can't promise to perform something you're already obligated to do, right?
Yes.
So I don't have nothing that don't apply to you. You have no further consideration to get. Okay,
Correct.
go ahead.
3, a promise made to a third party. Note privity of contract. A third party cannot enforce a contract between two parties of which he is not one of them.
Right, so if there's so in the instance of me being insured, so I have a contract of insurance, it's between me and the insurer. My passenger cannot go ahead and enforce my contract of insurance because it was only between.
Me and the insurer.
So you can't enforce something that you have no,
You're not a party to.
you're not a party to it. Now, this could be, there's an exception to this as well, but we have not gotten there. So this could be where we have contracts of employment or where there's, let's say, for instance, they have a case where there was some vacation happening where there was they had an agreement between themselves and I can't remember the case clearly, but it's more or less, there was no contract between the parties together, but the third party was obligated by extension of them being a party to the offer, more or less. So the offer made an offer, and the only way they could have made the offer is through this third party. The person who accepted, now the client, was able to go after the third party, notwithstanding there was no contract between those two, but based on the fact that by relation. So we have that in cases where there's employment, where there are employees driving vehicles,
Yes.
company vehicles.
Right.
So as much as there is only the employee driving the vehicle and they marsh your car, do you just go after the employee?
No.
You go to the employer,
Sure.
right?
Yeah.
Because by extension, they are an agent of the employer. And had it not been for the employer, they won't be on the road driving this vehicle. Yeah, so as much as that's where it may be an exception in that instance, where there's no contract between you and I, or we have no relation other than the fact that my employee has now caused you some harm, and the only way I'm now involved is because they were in the course of their employment, and now I've now been a party to this action. Go ahead.
4, promises which have no monetary value. Example, gifts of natural love and affection.
So that's not consideration. So me just doing things for you out of my, as a parent, that's not consideration. So, you know, a lot of parents tell you, you can't, you asking me or telling me to pay you. You can't ever pay me for what I've done for you. But that was what that is.
Love and affection.
What that is. Are they asking? Can they now ask for money?
No,
No.
it's gifts of natural love.
Yes. So that's where we could use that. There's no monetary value there, eh?
Right.
All right, go ahead.
Notwithstanding the foregoing principles, particularly the fact that a promise cannot be enforced and will not be considered a contract unless some consideration or value is given, the principle of equitable estoppel states that a promise freely made can be used as a defense to vary an existing contract, if that promise has been acted upon by both parties.
Okay, so where there's consideration, there's no consideration, there's no contract, eh? However, equity will step in where we can vary a contract based on a promise freely given, and both parties acted upon that promise. So as much as the employment contract states that I'm only to do certain things, I'm employed as a receptionist. However, I've been doing messenger duties. I have done secretarial duties. And I've done these things based on the fact that you said, you know, we short staff. However, if you could take on these roles, I should be able to provide, give you an increase in a few months based on once things have changed in the company, or I will give you a raise in a few months. I'm not able to do it now, but give me until June and I'll give you a raise. I'll give you, I put a condition, I give you an extra $50 a week once you can perform these duties for me as a backup. So you're gonna assist me in doing some secretarial duties, you'll do the receptionist duties, and you'll help with the messenger work from time to time. If I've acted on that promise, I've been doing these things, and you've accepted me doing those things, and when June comes now, you said you are employed as a receptionist. We have nothing in writing for you to be doing this. You just and I have nothing for you. What now I can do? What am I going to say?
That because I carried out the actions that you asked me to do, we actually had an amendment to our original agreement.
And what have
I
you
did
done?
it and you accepted it.
Right. What have you done as the employer?
You verbally
Accepted.
engaged them in additional.
Right. So you varied my contract, eh?
Yes, and accepted the conditions.
Right. So you varied my contract, and both of us acted upon those promises that you've made. And so now I can enforce the variation of the contract. I need the consideration. So sometimes employers vary contracts with the acceptance of the parties by their conduct. And so consideration must be given if you've made a promise that you would give certain consideration if they've done certain things. So their conduct is what would we call conduct in that instance? Conduct of the parties can demonstrate what? Yes, acceptance. Your conduct indicates acceptance. And so both parties' conduct notes that some promise had to be made based on me now doing these extra duties, because I don't know that me as an employee will take on so much additional duties without some offer being made to me for some increase. Yeah? Okay, let's continue.
Intention to create legal relations. Generally, agreements made in business relationships are legally binding, as it is presumed that the parties intended to enter into legal relations. Social or domestic arrangements are not considered to be an indication of an intention to create legal relations. Contracts may be verbal or oral or in writing, example checks. Others are made by deeds such as conveyances or mortgages.
The intention to create legal relations usually refer to business relationships. So social or domestic arrangements. So social or domestic could be in the setting of friendship or in the setting of family. So if I have an efficiency on my apartment, on my house, and I had a brother or sister who would have come along, and I allowed them to stay in the place for a period of time, and they didn't have to pay anything. They've been there for some time, so now they say they want to add something on the house, or they doing some other things. They've been there for such a long period, but I said, you know, I'm now thinking about expanding my house a bit, and I need my space. I've given you long enough to be in here. They would now say, no, I've been giving you $200 a month. We have a lease agreement now. I've been here for over a period of time. There was an intention to, this is a business relationship. We are lessor and leasing. So you can't just tell me I have to leave. I'm not a tenant at will. You've now, I've been here for a period of time. We have a lease. What in that instance, is that a business relationship?
Yes.
Would you consider that a business relationship?
If monies are exchanged, eh?
Yeah.
Okay, but what kind of monies were exchanged?
$100.
Okay, but was this an intention to create legal relations? You think this a business relationship?
Not based on the context.
No, so this a domestic arrangement. So there's no business in this one, eh?
Right, even though money is
allowed you to stay
exchanged.
here. Right, I just allowed you to stay here during your hard times period. I never intended for us to be tenants, I'm the landlord and you're the tenant. I was only trying to help you out for a nominal sum. So there was never an intention that I anticipated you would be here based on the surrounding circumstances. It's only when I would have taken in a stranger and we had some formal agreement that we can now say there was an intention to create some legal relations. So it could be verbal or oral or in writing. But in this instance, this is a domestic or relationship. I don't think there was any business involved. So we have no contract. At any time, I can tell you to leave because I only allowed you in here as a family member. I usually don't rent this place out. This was for my son. He's gone off and I told you could stay here because you were experiencing some hardship. Yes?
Yes.
Okay, go ahead.
Ms. Dawson, just before you move on.
Okay.
So should the police be called in,
Mhm.
they would have the relative the police would be justified in asking the relative to leave without having to go through the court.
So you trespassing if I tell you to leave, right?
Okay.
If I invite you on the premises and now I'm asking you to leave, once I've asked you to leave and you don't leave, what are you doing?
Trespass.
Mhm.
But
Yeah, because we have no form, I allowed you to stay here. So now they'll say, well, you know, you've allowed me to stay here for a period. It may be beyond the police's capacity to now negotiate that, eh? So they may say, you may have to go to court because I don't know what to do in this instance. But now you can't show any lease, eh? But you could say I've been here over 10 years.
or the exchange of money, does that factor in at all? The fact that there was a payment from the person occupying the apartment to the person who owned it?
Well, what I'm saying to you is I've only asked you to pay the light you were using. You wasn't doing nothing. You wasn't paying me nothing.
You've been there for 10 seconds.
You were paying the light you were using. I wasn't asking you to pay for the space because my son was only using it and I know you're all experiencing some hard time. I wasn't asking you to do nothing. Anything that you use, I wanted you to ensure that you paid what you used. Just don't cause me anything, but I allowed you to stay here. So you were in a room in my house, more or less. Yes?
Mhm.
Okay, go ahead.
Capacity. In order to enter into a contract, one must be of sound mind and have the relevant authority ownership, or power to enter into a contract as a principal or agent. Those persons who are minors under the age of 18 or are deemed mentally incapacitated, drunks, have restricted capacity. A contract be considered valid, void, example, deemed not to have existed at all based upon the circumstances or lack of the essential elements of a contract, or voidable, example, capable of being made void.
Okay, so we have capacity, which is important. You must have capacity to enter a contract. So usually, children under the age of 18 are not able to enter into contracts. So even in employment, they can't sign contracts of employment. They may have to have a parent sign on their behalf. Or if they want to open a bank account, likewise, they may need someone, an adult, to sign or open the account for them to be able to have an account. And they can be named as a part, as in a minor, because I think that's what the banks usually do. Yeah. They have the adult as the primary, and they just have it for the benefit of the child. So at the age of 18, they may be able to convert it to their accounts, or they may open a whole new account. Yes. And likewise, persons who are mentally incapacitated are unable to enter into contracts, or drunks, known drunks, they have restricted capacity. So you can't say, everybody noticed the town drunkard, and now you're saying they signed over their house to me. How could I have signed over a house, and you all know 7 days a week, 24 hours a day, I drunk? You just taking advantage of the situation. You feed me a lot of rum at the time, and you probably offered me a bottle of rum and say, sign this document and I would, I'll give you this bottle of rum. So in that instance, they could prove that, and they'll be able to say this contract is what?
Void.
Yes, because they didn't have capacity. So we have offer, acceptance, consideration, intention to create legal relationships, and capacity. Discharge of a contract, continue.
Ms. Dorset, one quick question.
Go ahead.
Mentally incapacitated. Now, I know that means if somebody is out of their mind, but could somebody sick in hospital also be considered mentally incapacitated?
Okay, so in the instance of, let's say, persons, whether in the hospital or of their senior persons, you would usually want to have a doctor to pronounce or give you some report that they're mentally able, of sound mind, to sign or give some instructions, because it could be challenged, Yes. So in the instance of someone preparing a will, where a person is, say, some 70 odd years old, you should have a doctor's report to say that they are mentally sound and fit to execute a will. Okay. Unless the will could be challenged, because I may say, you know, my parent had lucid moments, but they suffering from early onset dementia. So the doctor would be able to say whether or not they have lucid moments, because they could be lucid moments that they have. But where in that instance, it's most important that you have a doctor's report where someone is in the hospital, because they can be signing something under duress, or they may not have had a lucid moment, or they may be out of it. They may have been under doctor's care, under heavy drugs, all of that stuff. And they they didn't know what they were signing.
Okay.
Any other questions?
No.
Okay, let's go ahead then.
Discharge of a contract. A contract may be discharged in 4 ways. 1, agreement. The parties agree to discharge the contract, and this agreement is supported by some consideration. 2, performance. Both parties are required to perform their obligations and duties under the terms of the contract completely. 3, breach. A breach of a term or condition in the contract gives the innocent or aggrieved party the right to sue and/or treat the contract as having been discharged. Frustration. If an agreement becomes incapable of being performed due to some event outside of the control of the parties, and then it may be discharged due to frustration. Example, death or incapacity of the person who is to perform an obligation under the contract, destruction of the subject matter of the contract, non-occurrence of an event which the contract is based, etc.
Okay, so we can discharge the contract by agreement. So both parties will agree, you know, something. We can't continue with this. This don't make no sense. Let's just stop this contract here. So I may have you I have you as my contractor to build a house, and I had some changes to it, and you're unable to make the changes. I asked the contractor, say, you know something, I can't continue this. This ain't making no sense. You may need to find somebody else who could do this work. Just pay me for what I've done so far, and then you could perhaps find somebody else. I may be as the homeowner saying, yeah, I want some special work done, and since you're not able to do it, I'll go ahead to someone else. So we agree to discharge each other from the agreement. So that's by agreement.
Ms. Dossett, you're gone again.
Hello?
Hello?
We can't hear you, Ms. Dossett.
Sorry, I was trying to get it up again. Okay, so performance. So once I've completed what I've had to do, I had a year contract. I was supposed to make certain deliverables. I've delivered what I was supposed to do in that year contract. So both of us have done what we have to do. You've paid me, I've delivered. So the contract is completed by performance. Breach. What could be a breach of a term or condition in the contract? What you think could be a breach? Give me something that may breach a contract.
Failing to deliver the service at a specified time.
Right, so that's a breach. And so now, if you fail to do something, what could happen?
You're in violation of the agreement that you have.
So the aggrieved party, whoever the breach is against, can now sue for what? They can sue you for breach, or they can treat the contract as being discharged. I hired you to do something as a contractor, you're unable to do it. I am able to get somebody to fill in. So you can't do it, I move on to the next contract, eh? So I'm discharged from the contract because you're unable to meet the terms, eh? Likewise, in the contract of employment was a breach. What could be a breach in the contract of employment?
Not showing up for work.
So that's the breach. And so what I can do,
Terminate you.
Yeah,
Terminate.
so I discharged that contract based on you breaching the terms of your employment contract, which is job abandonment.
Yeah,
What could be the breach by the employer,
not to pay.
right? So I can now sue you for payment, eh?
Mhm.
You think I want to continue in employment after I sue you for payment?
No,
No.
Frustration, what could be frustration?
not supplying what's needed for the job.
So, but is frustration is within what? Is it within their capacity to do it? So what
No.
we said about the contractor, was he able to do a specified job that was outside of his scope, eh?
Right,
Outside
so
of-
it varies.
Right, so he was incapable of performing, so the contractor is frustrated by his incapacity to perform what I'm looking for. So
he
it's
won't
outside
sign.
of the control of the parties.
That's
And
correct.
we could discharge it. It also could be on the death of the contractor or incapacity to continue in this instance, or destruction of the subject matter. Can I continue with the contract if now we had an agreement for me to renovate the house, and I began renovating, but the next day some unforeseen event happened. A hurricane happened, the whole house is gone as a result. Is the contract able to be performed?
No,
So we discharged by what?
Frustration.
Yeah, because the subject matter is now destroyed, eh? The subject matter was the renovation of a house that's no
House.
longer in existence,
correct.
right? So in the instance of non-occurrence of an event, what we can use for an example of that? COVID frustrated a lot of things, eh? Give me an example of what COVID may have frustrated. An event that I had to do certain things based on this event happening. The event couldn't happen because of
COVID.
and therefore, am I obligated?
No,
No, so I'm not obligated because it couldn't occur based on something that's outside of the control of all parties.
right.
Yeah. So we have that with your flight cancellations as well, eh? We had to go on the plane, but the plane can't fly because COVID.
Or lockdown.
Lockdown caused a lot of things to be frustrated, eh? Even
Yeah.
jobs, all the employment contracts were frustrated based on an event outside the control of the parties. Okay, let's go to the remedies.
Remedies for breach of contract. There are common law and equitable remedies for breach of contract. 1, damages. 2, action for an agreed sum. Example, contract requests a price to be paid for goods or services. 3, quantum merit, as much as it is worth. Under equitable principles and
Okay,
agreed.
so sorry, before we go to equity, let's see, common law provides us with remedies for breach of contract. So we can get damages. So damages could include what? In the instance of you finishing my house within 3 months. In the instance of a employment contract where I expected to work for a period of a year, but now you terminated or discharged me of the contract after 3 months. So what I want in damages,
The difference of my money.
right? I want the difference of the sum of the contract. I may institute an auction for an agreed sum. So there's a price to be paid in this instance for goods or services. In the instance of what? Goods or services. Now in damages also, we should include in there, not only am I looking for the amount that I should be paid, but basically I anticipated that I'll be working for a period of 2 years.
6 months. Fair. If I want the difference.
Right, and additionally, I turned down another job offer based on you offering me this job. It was, and you would be well aware of that. We discussed that in our,
Meeting.
interview. I've left a very stable job because you came looking for me. And now, I was at a higher ranking. I came here, now you want to demote me to clerk, and I was, manager of a department. So I am suing for damages as well, and all these I would be considering what I would have been earning, how long I was employed there, what my chances of future employment was, how is this gonna affect me in the future with working again, all of those things I may consider for damages. So action for an agreed sum, we looking again at the amount that you agreed to pay me for the things. I want that. I want just what I was supposed to get, or quantum merit as much as it is worth. What is the worth of what I'm supposed to get? That's all I want. I want as much it is worth to both to us as a part, to me as a part. Okay, equity.
Under equity, equitable principles, an aggrieved party to the contract may seek: one, specific performance, a court order which directs a party to perform his or his part of the bargain under the contract. Two, injunction, a court order which prevents a person from doing something. Three, rescission, a court order which effectively ends, terminates the contract and places the parties back in their original position before the contract was entered into, or had the contract not been made. Four, rectification, a court order which corrects the mistakes in a written document. These equitable remedies are discretionary by a court and may be made, particularly if damages are not an adequate remedy for the breach.
Okay, so specific performance. So in an agreement for sale, we had an agreement where I'm gonna purchase this property for $70,000. I've fulfilled all of my obligations under the agreement. As the purchaser, you as the vendor now, you're supposed to give me a place. You told me the furniture was gonna be included, certain things were in place. Now when you get to the finalizing of the house, I'm moving into the house, I'm doing my final inspection, you've moved all of the furniture out. So now I want you to adhere or recognize the bargain we've made. I want all the furniture in, or you may say, gee, I agreed to sell this house for $70,000. This fellow come now say, listen, get rid of that. I will give you $100,000 for that house. I've now said I'm not proceeding with the agreement for sale. But the purchaser has met all the terms of the agreement. The purchaser can now sue you for specific performance for you to continue the sale, notwithstanding you have a greater offer. That has nothing to do with the fact that you've agreed to sell to the purchaser. So I want specific performance of the agreement. Injunction, I can ask for a court order to prevent you from doing something. I may ask the court to intervene and ask for an injunction to stop you from selling the house to the person for $100,000, because we have an agreement on the table, and until the substantive matter can be heard, I want you to put an injunction prohibiting them from selling this house. So that's another remedy. Rescission. So we can go to court and have the off the bargain completely ended or terminated. However, I should be put back into the position I was in. Both parties should be in the same position they were in as at the start of the contract date. So in order for you to put me back in the position I was in, I would have given you some $10,000 as a deposit. I have paid legal fees, I have paid appraisals, I've paid bank closing costs and all of those things. you can put me back in the position. You could go ahead and sell the house to the fella, but you need to give me all of that money back with interest and all my legal costs for coming here. Then both of us starting back where we were. You have your house and I have my money back. Rectification, so the court can correct mistakes in a written document. So it could be in an instance where we provided a conveyance and we incorrectly stated the property as number 11 when it should have been 12. We can rectify that with a court order stating that the parties made an error. And now the court recognizes the error based on the affidavit evidence. And now we'll provide you with an order rectifying the mistake. And now the property will be referred to, that is referred to in the document is now here and after referred to as Lot 12. And there should be some document now affected from this. We give the parties consent to do a deed of rectification and confirmatory conveyance of the property to move forward. Or we can say there was a mistake in the amount in the of the document based on all of the agreements beforehand, and the court can now rectify that mistake, or anything that was a mistake, we can now have it rectified under equitable principles. Of course, these are discretionary methods because equity is always at the discretion of the court. And it may be made where damages are not adequate. So you may get damages in addition to these remedies. Any questions? Okay. Who's going to continue for us?
I'm happy to.
Thank you.
Employer-employee contract. Employment law is a subset of contract law. Therefore, the principles which govern the various aspects of employment law are premised and directed by the law of contract, particularly as it relates to the nature, terms, and conditions and termination of the employer-employee contract. A formal contract of employment is a legally binding agreement between an employer and an employee, which stipulates the rights, responsibilities, duties, and obligation of both parties. As with any other form of contract, a contract of employment may be made orally, in writing, or a combination of oral and written terms and conditions. Although it is typically recommended that the formal employment contract be in writing to avoid the issues of potential conflict, evidence, ambiguity as to the employment duties, rights, and responsibilities that an oral contract may attract or cause. Where a contract of employment is made orally and there is clearly an intention to create legal relations and not merely an invitation to treat or bear promise which does not amount to an offer of employment, it is highly recommended that the employee obtain a written statement of the essential terms and conditions of employment within 2 months of the commencement date of the employment. All parties to a contract of employment are bound by the terms and conditions of the contract until termination by notice, variation, or breach of contract. There are only 2 parties to the employer-employee contract. 1, the employer, 2, the employee. All other persons or entities outside of the employer-employee contract are considered third parties and do not have privity of contract. Example, legal principle in contract law where a contract is only enforceable by the parties to the contract, as the employer and the employee. As a result, only the employer or employee may sue and seek the relevant remedies for breach and/or termination of the employer-employee contract, no one else. It is important to clearly determine who are an employer and who an employee for the purpose of recognizing and enforcing the rights, duties, and responsibilities of the parties. Equity is important here, as industrial employment tribunals and courts will look at substance, not form, in determining whether an individual is an employee or an independent contractor for the purposes of employment, notwithstanding the name or description that is given to a particular individual. By substance, we mean that it will be the nature and content of the relationship between the parties that are the subject of the contract that will often determine their legal recognition and definition and the attendant duties and responsibilities, not merely what the contract of employment names or describes an individual as. In determination as to whether an individual is an employee or an independent contractor depends upon whether that person is under a contract of service, which is normally the case for an employee, or whether he is performing a contract for service, which is normally the case for an independent contractor. In addition to the type of contract under which the employee is engaged, there are other factors that must be considered in determining whether an individual is an employer, employee, or an independent contractor. Based on the decisions of employment cases in England and the Bahamas, these factors include, but are not limited to: 1, whether the individual owns and is performing work for his own business or that of the employer. 2, whether the employer has certain degree of control over the individual engaged in work for him or under contract. However, the element of control exercise is not a conclusive factor in determining the nature of the contract employer-employee independent contractor relationship. Lane versus Shire Roofing Company, Oxford Limited. 3, whether there is pecuniary interest, economic gain, or financial profit to be made by the individual performing the work. 4, whether the individual is part of the employer's business or organization. 5, whether the employer provides the tools of trade and equipment to carry out the assigned work or the individual provides his own. 6, to whom is the legal responsibility and obligation to pay national insurance for the person engaged in the work or employee. 7, the party's intention to engage in an employer-employee relationship or an independent contractor relationship. Although the party's intention alone is not conclusive evidence in and of itself in determining the nature of the relationship between the parties. Ferguson versus John Dawson Limited. The parties' understanding and perception as to the type of relationship that was intended or exists between them. 9, whether the profession or trade is one that is designed for a particular relationship, employer, employee, or independent contractual relationship due to its nature and or structure. 10, the ability of the employer to hire and appoint the individual performing the work. 11, the nature and extent of the duty and obligation to work by individual engaged. 12, the payment of wages and salaries. 13, whether the individual performing the work will be assessed by the employer under a performance appraisal or other reward or recognition system as a process within the employer's organization. 14, whether the employer unilaterally determines the time and place of work. 15, the ability of the employer to discipline, suspend, or terminate the individual performing the work. As mentioned previously, in order for their employee-employee contract to be valid and legally enforceable, the following elements must exist. 1, offer. 2, acceptance. 3, consideration. 4, intention to create legal relations. 5, capacity. 6, certainty. Example, terms of the contract.
Okay, so the employer-employee contract. So the employer-employee contract should be formal, as it is legally binding. Where it is made orally, this is not in a social setting, so there's a business relationship, there's intention to create legal relations. Therefore, if I offered you the employment by verbally or orally, you should reduce that to writing within 2 months of the commencement of the date of employment. There are only 2 parties to the employee-employer contract, and that's the employer and the employee. No other persons can enforce the employment contract. Now, as much as on the face of it, we need that contract in writing, equity plays a great role in the employment contract because the courts look at the substance and not the form only. So that's how they determine whether the individual is an employee or an independent contractor for the purposes of determining what their employment was, especially in the instance where there's an aggrieved party who's come before the court. So what is the nature of the relationship between the parties would be determined by certain factors. And these are based on cases that have gone before and have been determined before the court. So we have to consider whether the individual is an employer, an employee, or an independent contractor. So in most instances, you know, employment contracts say you are a clerk. You don't have any substantial duties. You're only supposed to do certain things, but your work, the substance of it is you've been doing secretarial duties, or you've even been doing managerial duties. So this is important, is in particular in dismissing an employee, because the employer will want to rely on the form, which is the contract of employment, which states that you were hired as a clerk. However, for the last 5 years, you've not been a clerk. You've actually been managing and supervising staff. And this can be determined better based on the duties you are performing or how you're treated within the work environment. So some factors that have been determining whether you're independent contractor, employee, whether the individual owns and is performing work for his own business or that of the employer. So if you say you hired me as a consultant, I'm doing the job I'm supposed to do within your in your workplace. However, I'm doing this on my own time. I'm performing it as a part of my consultancy services. I may consider you to be an independent contractor. So I'm an electrician. I'm here working in your place. I've bought all the tools of the trade here. You don't provide me with anything. I gave you a quotation on what you would need, and I've performed the duty. So in that instance, you are working for your own business and not of the employer. So you're an independent contractor. Whether the employer has a certain degree of control over the individual engaged in the work for him or under the contractor. Whilst that's not conclusive, we'll see what the degree of control you have. Do you determine when I come and go, or I can come once I've completed this job? You have me to install light fixtures. You may say, now I'm only open from 9 to 1. So I have to perform that during that time, but you've not told me you have to come to work from 9 to 1, because now you're determining my work hours. I'm an employee of yours and not an independent contractor, because independent contractor would determine their own working hours. Whether there's a pecuniary interest, economic gain, or financial profit to be made by the individual performing the work. So am I an employee, an employer, or an independent contractor? Do I just get paid, or do I have shares, or do I have profit sharing? We'll determine what your position was within the company based on how you're paid, how you gain profits, are you offered shares as a result? So you considered a partner, you're the employer now and not an employee. Whether you're part of the employer's business or organization. So do you have me down as staff? Do you pay my NIB? I on your payroll system, so I am now an employee. Do you provide the tools of trade and equipment to carry out the assigned work, or the individual provides his own? If I'm an electrician, I bring my own tools. However, if I am your handyman, everything is on the premises and I use your tools to perform your work. So I am not an independent contractor. I am now your employee, because you provide me with all the tools for me to perform these duties. I am on a time schedule to be here, and I report daily to your workplace. You can't consider me an independent contractor, because the independent contractors have their own tools. Or you may say, I will provide you with certain tools to perform. When you get here, you could do certain things, but if there's too many factors involved, showing that you have control over how I perform my duties. It can be that of an independent contractor. I'm now an employee. Who has the legal responsibility to pay national insurance? If I have you saying that, listen, you're an independent contractor, I don't pay your national insurance, you pay your own national insurance. But all of the other factors play in. I have to pay my own national insurance, but you determining my hours. You giving me the tools to work with. So I'm supposed to be a consultant, but you provide me with the laptop, you provide me with a telephone. You tell me I have to be in here from 9 to 1. You don't give me any other perks of that of an employee, but all of the other circumstances steer me towards being an employee. The only thing that's different is I pay my own national insurance. The court will look at substance. As much as I may be paying my own national insurance, all of the other elements are there demonstrating that I am really your employee and not an independent contractor. The parties engage in an employer-employee relationship or an independent contract relationship. Now, their intention may be to do that, but that's not conclusive evidence in determining the relationship. All of these other factors will come into play. So the form may say you are an independent contractor or I am your employee, but I've been acting independently. I've done everything. I come in to work when I'm ready. I leave when I'm ready. You may pay my national insurance, but I determine when I'm coming into work how much I'm going to be paid based on the work I do. So it may change the characteristic of the form that we've completed as a contract of employment. What is the understanding of the parties in their relationship? Do I understand that I'm an independent contractor? Or do I feel like I am an employer? I'm an employee of this company. All directions point to me being an employee. As much as you said I am an independent contractor, you telling me when to come and go, you determining what I should do from what I shouldn't do to get the work done. You want me to do things at a certain time when I'm the independent contractor supposed to be providing you with the advice on how things should go. Whether the profession or trade is one that is designed for a particular relationship, whether it's an employee or independent contractual relationship due to its nature. Again, we can use the electrician. That doesn't seem like it would be one of an employee, where I am a professional electrician and I am offering my services to you. I come, I perform, and I leave. I am not here at any particular time. I may come here to finish something from 8 to 1 because I have several other jobs going on. So I'm only going to be there at a certain time. I may not even attend. I may send somebody who works along with me. So it's clearly demonstrated that I am an independent contractor. I am not your employee. The ability of the employer to hire and appoint the individual performing the work. So how is it? Can I am I able to say when I hire you, I can tell you to do certain things. When I hire you, I appoint you to do certain things. What is the relationship? Am I directing your every move throughout the day, or are you working independently? So how is the understanding, again, how is the relationship performed would determine whether or not we are an independent contractor or an employee. The nature and extent of the duty and obligation to work by individual engaged. So what is the nature of my work? How am I engaged? Am I engaged all day? Am I engaged part-time? Am I engaged 3 days of the week? Am I engaged at your beckoning, or am I engaged at my availability? So how is it done would determine, again, the relationship, the employer-employee relationship. the payment of wages and salary. Am I paid as a salaried worker? Am I paid weekly? As compared to me being an independent contractor and getting lump sum payments for delivery of services, products or services. So usually employees are paid based on the workplaces, how they pay their salary. Are we paid weekly like the rest of the staff, or are we paid monthly, bi-weekly? How are we paid will determine again the nature and relationship between employer, employee, whether the individual performing the work will be assessed by the employer under performance appraisal or other reward or recognition system as a process within. So basically, if you're doing a performance appraisal on me, it can be that I'm an independent contractor. The only thing you can do if I was an independent contractor was to say that we can renew your contract after a year based on certain deliverables. Have you met the deliverables? But not based on a performance evaluation that you would use for another employee, because then it's changed. The nature of the relationship has changed. I'm no longer an independent contractor. You've considered me an employee based on your conduct. Whether the employer unilaterally determines the time and place of work, again, I can't be an independent contractor when you tell me what time I must attend work, when I can leave, where I come to work. If I'm independent, I would tell you I'm able to work from home today. What do you need done? If it's something that I have to come into your office to do, then I will come in. However, I am unable to come there this morning. We can arrange another time. When you determine the times and places to say, oh no, you have to come between 9 to 5, and I need you here on a daily basis, you've now changed the terms of, you've unilaterally changed what I consider to be consultant. You've now changed me into an employee because I'm keeping regular hours with the rest of your staff. So, and now you want to determine when I can go to lunch, what time I should be here, what time I can leave, and I must come into the office. You're telling me where I should come to work as well. Whether you can discipline me, suspend me, terminate me, and performing the work will now determine how the relationship is. Are you giving me 2 weeks notice? Why are you giving me 2 weeks notice if we're an independent contractor? Our termination terms are set out in the contractual agreement, how we will terminate for breaches and the like. So when you start to use the terms of what you would use for your regular employee, you've changed the characteristic of how our relationship works out. So are you disciplining me? You suspending me? How can you suspend me if I am an independent contractor? The only thing you could do is terminate me. I'm not an employee. So when I get to the tribunal, I'll say as much as we were supposed to be, it's on this, it's in the form that I was employed as an independent contractor. All of these things have taken place. They wanted to tell me when I can come in. They changed the hours I come in. They put me on a lunch hour. I was dismissed or suspended for a period of time. He wanted to do a performance appraisal on me. So he's changed the characteristic of what the form says. So I should be paid based on me being an employee and not an independent contractor. So certain things will come into play. You will now have to pay me for the time I've been there. I should get this 2 weeks. I should get this because I may have been an independent contractor for a number of years. And my contract was renewed annually, or you may have given me an independent contract for a period of 4 years. And you've changed the characteristic of that to that of an employee. I've been supervising staff. I've been acting as a manager. So you're going to have a lot more to pay me than if we were still in the contract of employment as an independent contractor. Any questions?
I have one. How many of these 15 points need to be proven to determine that a relationship is one or the other, independent contractor or an employee? Is there a percentage or? What's
No, certain things will definitely determine, so they'll, unless something could be proven contrary. So I can say, well, you know, I only told them to come 9 to 5 because the office was only going to be open 9 to 5.
Mhm.
But then I can counter to say, well, I mean, the office was only open 9 to 5 for a whole year. You, as a consultant, I had to come there every day.
Mm.
Some days I sat there, I didn't have anything to do, but you obligated me to sit there daily. You told me I only could go to lunch from 1 to 2. So as much as that, so then there's something, well, I'll say, well, you know, I told you to go 1 to 2 because the office closed at 1 to 2 and everybody would go at that time. So I, as you were not an employee, I couldn't leave you in the office. Then I could say, well, I didn't need to be there in the first instance. So it's always up and down. So it may be, you may pull this point out and then they come with something else. So then you'll show another aspect of it. But it doesn't have to be all of these have to play a part because, of course, all of these don't relate to the same thing.
Mhm.
So it only, you may only need to use 1 or 2 out of it just to prove your point. And then you would have cases, because these come from cases, and you would say, based on this case, this is on all 4. And so basically would be using,
Standards of
when
proof.
this case on all 4,
When the case is, sorry?
when the case is the same, would be using from that case before.
Oh, what is it?
It's the principle and what the principle is called. Mhm.
The binding precedent?
And what that is.
Persuasive, the binding precedent.
And what the binding precedent is called, the Latin term.
Is that the stare decisis?
We stand by the decision, but what is the binding precedent called?
Is that stare decisis?
That's them
Yes.
standing by the binding precedent. What is the binding precedent called?
The ratio descendi.
Yes, right. The ratio descendi. So we stay, so basically the ratio in this case determines that I am not an independent contractor. I am an employee based on everything that's happened. All of the facts are the same. There's no distinguishing, so that's the same. Okay? Any other question?
In a case where the offeree of the contract says, I want to prove that I was an employee, not an independent contractor, because you provided me with the tools. But if the employer says, but you weren't allowed to take those tools off site at the end of the day to use for whatever else it is that you do, that would be the counter to that, right?
Right, so I provided you with the tools during the day and I allowed you to use the tools to do your other work in the evening. That's what you're saying?
No, that the employer counters and says, yes, I provided you with tools, but you were not allowed to take them off of my premises to use for anything else that you're doing. You could only use my tools on my premises, as an argument that you were an independent contractor who just didn't have tools that I provided, or the tools you needed were specialized that I provided for you to bring your expertise to do the job.
Right, so then I'm countering to say that whilst I provided the tools, it was only because you didn't have the tools that were necessary to provide the service I needed.
Right.
So I'm countering, you provided the tools, however, it was only because I provided the tools only because you didn't have the tools that were necessary to execute the work.
Right.
Yeah, so they could do that. Because then your argument will be moot now because you couldn't provide the tools I needed you to complete the work. So that was a part of the agreement. I will provide you with the special tools necessary because you may have needed an excavator
Right.
And you don't have an excavator, I have one on premises, I just need you to move it around. You have the skill set to move it around. I have it on site, I just need you to move it. And I only need you to come there for about 3 weeks.
Okay.
Any other questions? Okay, let's continue. Next, who can help us next? You want me just to volunteer? Or no? Okay, let me call someone off the list. I don't think Jay McDonald is here. Jay McDonald, who's Jay McDonald? I don't see them. No? Okay, Z DeVoe. No appearance.
I'll read.
Okay, thank you.
Offer of employment. Following the legal principles of an offer in contract law, the offer that is made by an employer to an individual under a contract of employment must not only be clear and unequivocal in and of itself, and demonstrate a clear intention by the employer to be bound by the contract, but it must also be communicated to the individual to whom it is being made by the employer. There should be no ambiguity or confusion as to the offer being made to the individual, although the specific terms of the offer may be detailed in the employment contract. There are some instances where the offer of an employment contract is subject to certain conditions, whether it is the completion of vetting and background checks, or the provision of references, or the issuance of valid work permits, example, expatriate workers. Whenever these preconditions are relevant to the particular offer of employment, they should be drafted to effectuate the legality of the contract of employment only when they have been satisfied. Alternatively, the contract of employment may be drafted in a way where it may be legally binding between the parties once all other elements of a valid contract have been met, but may be terminated if the preconditions are not or are unable to be satisfied after the contract has commenced or become legally binding.
Okay, so we have the offer of employment. It should be clear and unequivocal and demonstrate the clear intention of the employer to be bound by the contract. And it must be communicated to the individual to whom the offer is being made by the employer. There should be no ambiguity. So it should be made to who it's being made to, the individual. Now, there are some preconditions that you can attach to the offer of employment. And if those conditions are not met by the employee or potential employee, then the contract of employment would not be satisfied. So the offer is no more based on is subject to you meeting these terms. So in some instances, I may say I'm offering you employment, but basically you have to provide me with 2 character references from your former employer, good character references. And you need to provide me with a police record, a clean police record. Also, you have to show proof that you're a citizen of the Bahamas, or in the instance of me hiring an expat, I offer you this position basically once it's subject to immigration approval. So if you now accept the offer, you started working, you said you would provide me with these things within 2 weeks of employment, and within the first 2 weeks, you're unable to provide them, or when you provide them, they're not what I've asked for. It's not a good character reference. Your old employer is bashing you to say not to be trusted, is a poor worker. Your police records say you have some criminal charges pending, or you have been convicted of some crime, and you are unable to provide me that you have status to work in the Bahamas, then I can now say your services, your office, your acceptance, and the contract is null and void because it was subject to these terms being met. So that has to be clearly drafted to effect, to ensure that the you can now move away from your offer, which is clear, what has been clearly communicated to the employee. Okay. Go ahead.
Acceptance of the offer of employment. The offer of employment may be accepted by a potential employee either expressly or impliedly. An offer of employment may be expressly accepted by the potential employee orally communicating the acceptance to the employer or his, her, its authorized agents, or by formally signing the contract of employment. It may be impliedly or indirectly accepted by conduct, example, arriving to work and working on the job. Again, following the general principles of contract law regarding acceptance, in addition to the foregoing legal requirements, the acceptance of an offer of employment may only take place while the offer is still open, and the acceptance must be unequivocal. In other words, it must be absolute, unqualified, unclear in its expression. No conditions may be attached to the acceptance of an offer, and it cannot be considered a counteroffer. It must be noted that the lack of agreement between the parties on a particular term of the employment contract, for example, the parties' lack of agreement on remuneration, does not invalidate a contract of employment, as an implied term may be imported into the contract by an employment tribunal or court that a reasonable sum will be paid for work done in certain instances. HR Tech v. Stack 2012 CA. Another legal principle that should be highlighted is the fact that an unconditional job offer that has been made by the employer and accepted by the employee creates a binding contract of employment. Consequently, any withdrawal of that unconditional job offer by the employer will amount to a breach of contract and a termination of employment. The aggrieved employee may then be able to bring a claim against the employer to an employment tribunal. If the claim is successful, the tribunal may order the employer to pay compensation to the aggrieved employee, which may be equivalent to the contractual notice period. Sarkar v. South Tees Acute Hospital, NHS Trust, 1997, UK Employment Appeal Tribunal.
Okay, so acceptance of the offer. So the employee accepts the offer potential by communicating their acceptance to the employer or by formally signing the contract. So it may be implied or accepted by conduct. So we say, you come into work, you start working, we would have assumed you have accepted the contract based on your conduct. So it must be unequivocal. You can't put conditions on it. So now I've given you an employment contract. I said you're hired as a secretary. You apply to be a manager or an accountant. I said I only have a job as a secretary. That's the offer I'm making you. And you said I accept that. I only accept it as working in your accounts department. You've now repudiated or rejected my offer, right? So that's a condition. So no longer, that contract is now out the door. You have no offer of employment because you've answered me back saying I only accepted as an accountant. I don't have an accountant position, so you have no grounds to stand off. You have no longer a contract of employment. So if we don't agree on remuneration, that doesn't change or invalidate the contract of employment, because whatever was the reasonable sum based on the surrounding circumstances may be implied into the contract by a tribunal. So I would say I sent you the employment contract. There was no consideration because we've not reached the point of where we put the offer on the table. We were dancing around, say $600, and you decide, and I was looking more for 600. You were looking at 500. But I started working, notwithstanding we didn't confirm the amount, but we know what the range was. I started paying you $550. That does not invalidate, because you were saying, oh, I was looking for 600. That doesn't invalidate the contract, because it was reasonable based on the offer, the initial offer, the range, the salary range you were well aware of. So 550 would be reasonable, or 500 would have been reasonable because I gave you a range. It's between 500 and it caps at 600. That doesn't invalidate the contract of employment, because it now can be imported into the contract. The unconditional job offer being accepted by the employee is a binding contract. So we have an oral acceptance. So if you now decide to withdraw that job offer, I, as the potential employee, can now bring a claim against you. And what I may bring the claim for? What I could sue you for?
Contract for payment.
So I'm looking for some compensation, eh?
Mhm.
I want you to pay me compensation since you withdraw the offer, equivalent to the contractual notice period. So you had a period you would have had that term in there to say this contract will be terminated within, I can terminate this contract after a period of 6 months or whatever the period is. I want compensation in that amount. You can't just withdraw it. You've now breached the terms of our contractual agreement. Any questions?
That would apply if the passage you're referring to was something similar to, say, a probationary period, or not?
Right, so that's the contractual notice period, eh? So after 3 months is a probationary period, or after 6 months, we'll decide if I'm going to continue, if you will continue. So based on your performance after 3 or 6 months, I will consider whether you will continue working with me, because you have a probationary period to go over.
Right, and that would not be a breach because that's written into the contract.
No, remember now, we're talking about I offer you employment unconditionally and I withdraw it before you even began.
Okay, so that speaks to what? The notice period then that is required by law?
So we have a contractual notice period. So so we have a notice that at the end of, if I'm gonna, after 9 months, we'll decide, or 3 months before the end of this contract, I'm gonna try to, within 3 months before this contract ends, either party will give notice of it being renewed. So that's the period. I'm looking for at least 9 months of employment, eh?
Right.
Or this contract is subject to probation, 3 months probation. So you have 3 months of probation before I decide whether or not I'm going to keep you. So what should happen?
If we're discussing the probationary period and the performance is, or there's some breach, some failure
No,
to
this
deliver.
before we get to the period. That's the period I can use that you should pay me.
Okay.
You see? I've never even been allowed to work. You withdraw the offer before I started working, but I've already accepted it.
Okay.
So I want some compensation. What period am I gonna be compensated for is to be determined here by what? The contractual notice period. So
Yeah.
you had a period of, I was, when I started working, I still only had 6 short months or 3 short months before you decided whether or not you were gonna keep me, right?
Mhm.
Yes.
But you didn't allow that 3 months to take place. You have withdrawn your offer, so I'm going to the courts now or the tribunal, and I want you to pay me for at least that period where I would have been employed definitely. You see?
Okay,
Because you know the probationary period, once I start working, I may not work out.
right,
So I can dismiss you anytime during that probationary period, eh?
right.
But now I've never started, so I using that probationary period to get the full money. I may not have got, I may have been a lousy worker. You should allow me to come in for 1 month or so or a week, and you would realize you don't want me. Instead of
Right.
withdrawing the offer before I started, let me come in and say you're not working out. Then I didn't have to pay you anything. You
Okay,
see?
yes.
All right. Any other questions? Okay, let's continue.
Consideration. The consideration for the employer-employee contract must demonstrate an exchange on the part of the employer and employee. In other words, the consideration for the offer and acceptance must also be supplemented by some clear demonstration of a change of hands in terms of what is being promised and delivered. The consideration is often the employee's performance of the assigned duties under the terms and conditions of the contract, and the employer's salary payment to the employee for work done under such terms and conditions. Any additional obligations which may be required to be performed under an existing contract of employment, whose terms may be varied or amended in any way, must also be supplemented by a consideration that is clear and unequivocal in scope and meaning. Intention to create legal relations. Unless made in a purely social and/or humorous context without the intention to be taken seriously, most formal employment contracts demonstrate clearly an intention to create legal relations. Capacity. Both the employer and employee must have the relevant legal capacity to make a contract of employment between each other. For example, minors and mentally challenged persons do not have the legal capacity to enter into a legally binding contract on their own, as they either do not have the requisite legal age of majority consent or the requisite mental capacity, that is, being of sound mind and able to appreciate the nature of the act of entering into a contract of employment. Persons declared bankrupt are also considered ineligible to enter legally binding contracts of employment based solely on legal capacity. However, certain practicalities and/or social custom may have overlooked or overwritten this legal requirement in the interest of assisting the bankrupt individual to engage in meaningful employment to better their condition. As it relates to employers, the legal capacity that is required for a binding contract of employment may be in terms of the employer's capacity to enter into and/or authorize a contract of employment, particularly in the context of certain legal principles regarding the law of agency, and in terms of the corporate or other legal capacity to make an offer of employment. Example, illegal businesses operations may not make validly enforceable contracts of employment, etc., or companies who may not be in legal good standing at the time of the offer of employment, although this is subject to a case-by-case legal analysis of the facts. An employee's capacity to enter into and enforce a contract of employment is important to ensure that his rights are recognized and protected by the employer. The employees who may not have the legal capacity to enter into an employment contract, example, due to a lack of permission or work or right to work in a certain country or industry may not enforce an illegal contract. A claim cannot be brought by an individual under an illegal contract to enforce the terms of that contract, particularly if the individual has colluded with other person or participated in the in any way.
Illegality. Mhm.
That's tongue
Yes.
twister for right at that moment.
Yes.
2012.
So we have capacity. They must be legally able. They should have what? They should be of legal age, sound mind to enter into a contract of employment, eh? Declared bankrupts may not enter, but they may allow them to do so in order for them to get out of the situation they're in, eh? The terms of the employer's contract capacity to enter the contract may be challenged as well, whether it's agency or whether it's illegal business operations. Now, you know, at one time we had
The number house.
right on the head. You hit the nail on the head. So you working for them was not what? Was that something that could be enforced?
No.
Because it was an illegal business at the time, so it was contrary to the law. So you can't enforce something that's against the law. Or if the company is not in good standing, so they may not be paying their business license fees, they may not even be on the register, they may be struck off the register. So there's nothing to enforce because they don't even have legal standing in the community. Again, employees in this instance may not have the capacity to enter into the contract because, first of all, you are a foreigner to the land. You need certain approvals to enter to work here. If you have not gotten those approvals, then the contract is null and void because it's what? Contrary to?
The law.
Yeah, so it's an illegal contract. There's no capacity. There's no contract. Okay. Let's continue.
Certainty of terms. To avoid ambiguity and any potential legal liability, unanticipated legal responsibility or obligation, the terms of a contract of employment must be drafted and represented with clarity and certainty as to the nature, ambit, and scope of employment. Certainty of employment contractual terms is critically important as it provided the underpinning and framework for the employee-employee relationship.
So the terms must be certainty. There should be no ambiguity. We should know what your nature of the employment is, what's the scope of your employment, what your duties are. Make sure everything is clearly spelled out. So let's go to the standard terms. Go ahead.
Okay. Standard terms and conditions of employment. The terms and condition of a contract of employment may be express or implied. The terms may expressly outline the nature and ambit of the work to be performed, the duties and obligations of the employee, and the rights and responsibilities of the parties. Alternatively, or in certain instances, the terms of the employment contract may be implied due to the nature of the contract or the circumstances which give rise or relate to the contract. The standard terms and conditions that may be found in the typical contract of employment include, but are not limited to, the following items. 1, employer and employee names. 2, job title and brief description. 3, date of commencement of employment. 4, duration of employment, if applicable. 5, salary and or payment arrangements. 6, duties and responsibilities of both employer and employee. 7, hours of work. 8, benefits. 9, vacation. 10, national insurance contributions and sick pay arrangements. 11, pension scheme and other entitlements. 12, notice periods. 13, disciplinary and grievance policies and procedures. 14, collective bargaining or other agreements which may affect the terms and conditions of employment. 15, termination. These terms and conditions may be stipulated in both the letter of offer and the employment agreement. There may be specific items outlined in contracts of employment for executive employees or other types of employees. Where the contract of employment does not mention any of the aforementioned items, the employee handbook may provide further elaboration or guidance, although it is recommended that key terms and conditions be outlined in the contract of employment, as and where necessary for clarity and certainty as to the party's legal responsibility, accountability, liability, and other issues related to or affected by the terms and conditions of the contract of employment. Under Section 5(1) of the Employment Act 2001, the Act, an employer must inform his employee of the following particulars as soon as is practicable under the terms and conditions of the contract of employment. A, the name of the employer or group of employers where practicable of the undertaking and of the place of employment. B, the name of the employee, the place of engagement, and where practicable, the place of origin of the employee, and any other particulars necessary for his identification. C, the nature of the employment. D, where a person is engaged for a fixed period or in appropriate circumstances, the duration of the employment and the method of calculating the duration. E, the rate of wages and other benefits and methods of calculation thereof, the manner and period of payment of wages and other benefits, the advances of wages and other benefits, if any, and the manner of repayment of any such advances. F, where any work is to be performed, not by the piece, but by time, the number of hours of daily work, and the hours of the day of which such work is to commence and to terminate. It is important that the foregoing terms are included in a written contract of employment in order to ensure compliance with the law and to safeguard against unintended discrepancies in the terms and conditions mutually agreed by the parties. Other terms besides the aforementioned statutory or standard contractual terms may be incorporated into the contract of employment through custom and practice. Similarly, additional terms may be incorporated into the contract of employment, which may arise from the statutory and common law obligations imposed upon the employer and employee. Restrictive covenants may also be included in the contract of employment by the employer that restrict the actions of the employee either during the time of his employment or for a specified period of time after the employee has left the employer's place of work. Example, non-disclosure and non-compete covenants. Additionally, various case authorities have suggested that employers have an obligation and an implied duty to notify their employees of employment rights that they would not be ordinarily be aware of. However, if an employee knows about the such employment rights or ought to have known of them, then the employer's omission or inadvertence in not informing the employee about such rights will not amount to a breach of contract in law. Tasneem versus Dudley Hospitals, 2011, UK Employment Appeal Tribunal.
Okay, so the standard terms and conditions of employment. So the terms of employment should be clearly stated, eh? You should include the employee names, job and title and description, the date of commencement of employment, duration, salary, duties and responsibility, hours, benefits, vacation, NIB, and sick pay arrangements, pension or pension schemes, other entitlements, notice periods, disciplinary and grievance policies and procedures should be important. I should know where I could go, what discipline and grievance procedures are there, collective bargaining or other agreements, and how and when I may be terminated. So these things may be outlined in an employee handbook where you've not clearly included all of them in my contract of employment, you may refer to them in your employee handbook. Now, what is important is for you to know under Section 5(1) of the Employment Act, you must inform the employee of the following as soon as is practicable under the terms and conditions of the contract. So they should know these things. So that's mandated, by law under Section 5 of the Employment Act. You should inform your employee as soon as is practicable of these terms and conditions of the contract of employment. So they should be included in the contract, and they may now be incorporated by statute as well and custom and practice. So certain things are custom and practice. If you don't include it, it automatically, the Employment Act would now substitute where you've left out certain things. So for instance, after 6 months, I am entitled to 1 week off as an employee. If you didn't put that in there, the law states that it should happen. So by law, I'm entitled to that. If you didn't put it in there, that's fine. I'll just refer to the law and you have to give me my 1 week off. I am entitled to sick days. I can be off. I'm entitled to a day off. What the day off is?
24 hours, 24 consecutive hours in a 7 period.
Right. So I'm entitled to that. The law says I'm entitled to that. I can now have in my contract of employment as an employee, I could put in non-compete and non-disclosure clauses, and I can put a specified time after you would have left my employment that you can't compete with me, or the non-disclosure continues with you as long as you were employed with me. You can't disclose what has happened in my business once because it's now covered by our contractual agreement of confidentiality.
Ms. Dossett, I have a question on the non-compete. I have heard challenges on that in that if the business is, if the employee and the employer are in the same business, let's say it's as an electrician, someone hires a person as an electrician, and then they're terminated, that the non-compete can't be upheld because the person, the individual, the employees, the nature of the business or what they perform is as an electrician. Does this mean competing in any capacity in that field, or they can't start an electrical company that competes now with their employer?
Okay, so the non-compete clause in that instance, because you can't prohibit me from putting bread in my mouth,
Right.
If that's the only job I know how to do, then that's, but the non-compete is you can't go to my competitors and compete against me. So if I'm an electrician, I shouldn't be competing with the business I just left. So I was working with Flameless Electrical, and they had a client that I was aware of based on me working with them. I can't now go to that client when I've left to now say I could offer you a better rate than Flameless.
Solicit that client.
Right, so you competing with me in that instance, but not in the instance that I can provide the service. So I'm working with the bank. I have a non-compete clause that you can't work with my competitor for a period of at least 6 months. Give me a chance to get what I've given you to put into play before you get to those people and say the same idea you would have given me now, you could give to them. So now you gave me a way of working around certain things, and I can now attract customers based on the ideas that you would have given me. So now I'm telling you, you can't work for any of my competitors. You've signed that agreement that you won't work for my competitors, direct competitors, for a period of 6 months after you would have left my employment. So that gives me a chance for you not to go ahead and cause me to lose out on what I've had advantage of with you being in my employment, because I may have sent you on training just for this particular period of time in order for us to bolster our product. And now you've gotten that information and you're able to now utilize it for my competitor. No, I'm going to need to protect what I've given you, which is some intellectual property at this time. You could use it after 6 months because by then I would have already been able to fulfill my plans, but I'm not going to allow you to go out there and compete with me for at least 6 months after you would have ended employment with me. You could go to be anything else, but you can't go in the bank that's competing with me. You could go in an accounting firm, they don't compete with me, but not in the same field and not what I'm trying to do as well, where you would be competing directly with me as the former employer.
Okay.
Okay. Okay. Next, I know Ms. McDonald helped us out good, so let's try someone else, please.
I can continue.
Thank you.
Validity of employment contracts. In employment law, a contract of employment that is not signed by any one or more of the parties is still valid and enforceable, particularly if the parties have carried out or adhere to the terms and conditions within the contract by their conduct. One example is where it can be proven that an employee is or has been working in accordance with the terms of the contract. In that instance, there is a presumption in law the contract of employment, inclusive of its terms and conditions, has been accepted, presumed that it has been accepted, presumed that it has been accepted. F.W. Farnsworth Limited and Lacey. That's a 2012 UK High Court case. Types of employment contracts. The type of employment contract that may be used by an employer or the organization will depend upon the type of role and responsibility that it is seeking with regard to a permanent employee, temporary or fixed-term employee, contract worker, or apprentice. Number one, permanent employment contract. A permanent employment contract is normally comprised of both implied and express terms and should incorporate the statutory and common law contractual terms in the agreement, in addition to any other terms which may be imported into the contract by way of custom or practice. A permanent contract may only terminate based upon the contractual terms relating to the termination included in the contract or other than termination based upon summary dismissal under the provisions of the Employment Act 2001. Number two, temporary or fixed-term employment contract. A temporary or fixed-term employment contract is an agreement between the employer and a temporary worker who is often hired on a fixed-term basis and ends on certain triggers which are drafted into the contract. That is, the temporary or fixed-term contract of employment may end on a specific date after a particular event or on completion of a particular task. Generally, temporary or fixed-term contracts normally terminate automatically when the agreed fixed term of employment ends. Unlike the United Kingdom, the Bahamas does not have,
25 boxes.
Unlike the United Kingdom, the Bahamas does not have an Employment Rights Act as the Employment Rights Act 1996 in the UK, which requires an employer to inform a temporary or fixed-term worker of the start date and the expected end date of his temporary employment. Under the principles of employment law, a temporary or fixed-term employee should not be offered new contracts of employment on terms that are less favorable than those of his original employment contract. Similarly, under the law of contract, an original contract of employment will end if the employee intends to change and actually changes the terms of the contract without the consent or agreement of the temporary or fixed-term employee. In such a case, a temporary fixed-term employee has grounds to make a claim for unfair dismissal against the employer. It is interesting to note that the United Kingdom that in the United Kingdom, there is the fixed term Prevention of Less Favorable Treatment Employee Regulations 2002, also known as the regulations, which allows a temporary or fixed term employee to make a claim requiring equal treatment as that of a comparable permanent employee in the same organization, inclusive of the terms and conditions of an employment relating to salary, pension, and training. The regulations also give temporary or fixed-term employees the right to be informed of any available vacancies, entitlement to redundancy after 2 years service, and the right for the individual's fixed-term contract to automatically become a permanent contract of employment after 4 years of continuous employment with the employer. The Bahamas does not have a similar piece of legislation which recognizes and enforces the rights of temporary fixed-term employees and dictates equal treatment in certain instances as permanent employees, as does the regulations and the Equality Act 2010 in the United Kingdom.
Okay, so we know that we have this permanent employment contract, which we have some people having now, but basically the leader of the park is what over here? Who's the leader of the park who's been abusing these fixed term employment contracts or temporary? And as a result, everybody follows suit.
The
Who is
hotels.
Hotels?
hotels, but who's the real person who the head is rotten? We have
Government?
people, the government, eh?
Government.
Yes, we have people who've been working temporarily for over 20 and 30 years. So we have no legislation. And I mean, this has to be by design, eh, because we have legislation in the United Kingdom that would stop this practice from happening. Because I can't be on, the banks have been doing it as well a lot. You have me as a temporary worker for over 20 years. That's unheard of, eh? I must have some stability. And if we had the employment, if we had these equal rights as in the United Kingdom, after 4 years, I would be entitled to a permanent contract, eh? So we have a lot of inequality is happening because as a temporary or fixed term worker, you don't have any rights as such. Now, I know the Employment Act has made it, the only thing that has come out of anything is that after 6 months, you will be able to get your little vacation, and you have to pay national insurance notwithstanding. But other than that, I can have you working every 6 months, and that's when your employment ends, eh? And when I look, you have a new contract, and when you look, I never get vacation if you work it out like that, eh? So there's some inequalities that can happen and the employee can be taken advantage of based on there being no legislation to enforce the equality of me being a regular worker. Okay.
Ms. Dorset, I have an observation.
Okay.
At a previous place of employment, we hired security guards on a contractual basis.
Right.
And in some cases, most of them were permanent employees, but we had cases where we had temporary employees, and we were advised by the labor board that there had to be a 3-month break between contracts in order for a temporary contract to be valid and not imply permanent employment.
Right. So continuity would suggest if I go to, I've not changed, I'm performing the same duties. You continue to employ me in the position, and you just keep renewing my contract. So what am I going to do?
Leave for better employment.
No, and if I don't leave and you try to dismiss me, I will want to show what?
The continuity of your employment with the company.
Right. So I want to enforce that. Now that has not happened a lot over here, but there's some cases that have gone before, like you said, where that has been enforced. Like people would have said, now you, as much as you were trying to keep me where you didn't have to pay me benefits, I have been continuous. I've been working continuously. I've not even had a week off in between. You continue to renew my contract. So it demonstrates that I am more or less what you working towards. I have gained some employee status, eh?
Yes. Yeah.
So I
And
may go to court. I want to go to court and say, you know, as much as you don't have legislation on the book, what we looking at inequity,
yes.
what
Yeah.
what it is.
Inequity between that part-time worker and your permanent employees if they're performing this at the same rate of work, the same continuity of work, but they don't
Right. So
benefit
what
from
for equity, what we looking at in this instance? The form or what?
the substance.
Yes, we're looking at the substance. So based on the substance, it seems as if you
This
were
would be a
trying to
full-time employee.
avoid something, but I've been continuously employed. So most of those people may be able to enforce something against the government after a lot of years, eh?
Mhm.
Because as much as they try to avoid it, there's some gray areas there that would allow loopholes for them to jump in. Yes, but
Yes.
it's just for them to
Dorset?
test it.
Ms. Dorset, I have a question. What
Hmm.
about, in that same instance, if an employee were working on a temporary contract, but their hours were not that of a full-time employee?
Right,
What-
so they want to make sure to keep it, they want to keep it so
they
that
keep-
it don't cross over.
It doesn't cross over. They never work the 40 hours a week. The hours are always capped, where they work maybe three shifts per week.
Right, so it's intentional and deliberate for them to make sure that they don't cross the lines. So what they're doing is ensuring that, okay, I know so just say for instance, I have to make sure I keep you part-time, that means you only can work 20 hours.
Okay.
If you work 1 hour over, then now you can now claim what?
Be a permanent employee.
Full-time. So
Full-time, that you're a full-time
right.
employee.
So now I get a little bit my benefits have to be different, eh? So
Yeah.
you want, so they have to make sure they police that very carefully as an employer, that you don't cross the lines, because then you don't want to blur them.
So if you
What
have,
is that line? Oh, sorry, go ahead, Glacius.
if you have an employee that on a consistent basis, they're working 20 hours below, let's say for years at a time, but occasionally they may be required to work an additional 8 hours, which could take them over, but it's not a consistent thing. They're working maybe 3 or 4 shifts a week every 3 or 4 months, but consistently they work under 20 hours a week. Could they then be entitled to full-time benefits?
So I'm working 20 hours a week, but at some point I'm going to go over that, even if it's not consistently. At any point I go over, then you've changed the characteristic, eh?
Okay.
Yeah, so now I was 20 hours for the last 6 months, but now this week I gone to 30 hours.
Mm-hmm.
So what happens there? Was I part-time that week?
You weren't part-time that week, you were full-time, but I mean, can you now come back and tell me that, okay, I need vacation, I need all of these other full-time benefits when consistently.
So you as the employer have to ensure that you don't contravene the law, or you need to say to them, listen, we have a special project that's going on, and now you can do this on the side if you want to. And we'll pay you separate and apart to make sure you clearly distinguish, because you can't assume anything, because what we doing based on my conduct, you've accepted it.
Okay.
Because if I perform it, that's my conduct and consideration, you paid me. So now what happens? You've changed our characteristic a bit, eh? And this may happen once every 3 months, and you have not policed it, and I use that against you, because I'll make sure to make a note of that. And it can show if I was punching clock as well. You know, as much as they say I was part-time every 3 months or so, they slide that in there. I was working like a full-time employee. They had me working an extra 10 hours a week.
Mhm.
But they were just trying to keep in line, but they mess up. Because once you mess up, eh?
Yeah,
You open the door.
okay.
So it's up to the employer to police it, and it's up to the employee to ensure that their rights are not trampled on, okay?
Right. So how many hours are considered the switch point where you move from temporary or fixed term to full-time? Like, is it 26? Is it 32? How many?
So
Is
the working week is 40 hours, eh?
Mm-hmm.
So I think you have to work half of that to be part-time, eh? Or you can be working for a period. So your part-time, maybe you working for 3 months. Or I may only have you to work 2 or 3 days. Because I reduce your hours. So I may only have you working 6 to 2 this day. You may work 9 to 5 the next day. But I make sure to keep the hours in line with part-time.
Okay.
Or you just on a fixed term. I have you part-time for 6 months. I make sure you finish within 6 months. And I may call you back after 2 months. So I could give you 2 months off and start you back again. So we have part-time, and then we determine how the hours could be, how much hours you could work as a part-time employee. And when I go over that, then it's much more. So just like the 40 hours per week, if I'm working more than 40 hours, you have certain obligations, and you have to pay me time and a half
Right.
for through the week, and on Sunday I think it's double time. So it's, you know, it all of these things factor in. So if you hired me from Monday to Friday and you now asking me to work on Saturdays, I've already worked my 40 hours. This is overtime now, because this can't be no work day, this overtime. So I'm looking for time and a half. So if you have me working 9 to 1 on Saturday, so I work in 10, 11, 12, 1, 4 hours. I want 4 times 1.5. So I should get 6 hours pay. Eh? If you want me work on Sunday and I work 9 to 1, you give me 8 hours pay, because I'm not a shift worker. Shift workers are different. Yes. Any other question? Okay, let's continue.
Okay, number 3, training apprenticeship contracts. A contract of apprenticeship is normally an agreement made between the employers and the apprentice, where the apprentice agrees to work and be trained by the employer for a specified time, pay, and under certain conditions. A traditional contract of apprenticeship is often governed by common law. However, there are certain provisions of the Employment Act 2001 which make reference to apprenticeships. An apprenticeship agreement is normally drafted and entered into by the relevant parties for the purpose of training and terminates when the training is complete. However, an employer may include early termination provisions subject to common law principles governing such contracts. Additionally, employers who engage apprentices or trainees under contracts of apprenticeship are not required or bound by law to offer employment to those apprentices or trainee at the end of apprenticeship period. That can be referenced at Northeast Coast Ship Repairers and Secretary of State for Employment. And that's a 1978 UK Employment Appeal Tribunal case. Illegal contracts. Even if the relevant elements of a valid contract are existent, it should be noted that if there are any terms of the contract that are considered illegal under law, the contract is considered an illegal employment contract, and the rights, duties, and obligations that comprise the terms of the contract or referenced by the contract cannot be enforced by either party. And that is referenced in Zarkasi and Anandita and that's a 2012 UK Employment Appeal Tribunal case. However, a contract of employment may not be considered illegal if it entered into between the parties in good faith. In considering whether an employment contract is illegal, the test for illegality was outlined in the persuasive authority of Enfield Technical Services and Payne, 2008 case in the Court of Appeal, where the Employment Appeal Tribunal in an earlier ruling stated that illegality is to be determined where the parties have knowingly entered into arrangements which have, to their knowledge, represented the facts of the employment relationship to be other than they really were. Whether the individual does not have the legal capacity to enter into or enforce the contract of employment, the terms of the contract are illegal, or some illegal act make the contract void or voidable. The existence of the essential elements for a valid contract does not automatically make the contract legally binding. However, every case where there is some doubt as to the validity of the contract of employment must be reviewed and determined upon its particular facts. Variation of the employment contract. Generally, the terms of the contract of employment may be varied by the mutual agreement of both parties or unilaterally by either party, depending upon the circumstances. However, where either the employer or the employee seeks to vary the terms of employment, either unilaterally or mutually, within the duration of the contract, the variation must be done with the express or implied consent of the other party. In the Bahamas, it is established law that no employer has the right to vary a contract of employment without the express or implied consent of the employee, unless the employee has given the employer the power of variation through contract or agreement. And that is referenced in Burdett, Coots, and Hertfordshire Council. That's a 1984 IRLR 91 and can be found at Queen Bench Division. Where an employer varies a contract of employment unilaterally and notifies the employee of this variation of the terms of the contract, and the employee does not agree with the change or alteration to the contract of employment, it is advised that the employee should make his disagreement known to his employer, preferably in writing, as soon as possible, notwithstanding the fact that he must still continue to work as agreed under the other terms and conditions of the employment contract. If the employer continues to carry out the variation exercise, the employee has a legal right to report and file a trade dispute with the Ministry of Labor or bring a claim or action against the employer in the Supreme Court for breach of contract. And that was shown in Cowie and Liberian Operations Limited, 1966, 2 Lloyd's reports.
Hello? Hello?
Probably having internet issues too.
Okay. Okay. Share internet issues.
Hello?
Hi.
Hi, sorry. I didn't even
Okay,
realize you lost me. Where did you lose me?
You now going to start frustration of employment contracts.
Okay. Sorry about that. We had the first paragraph. I didn't realize you had lost. Okay, frustration of employment contracts. Following the principles of the law of contract, a contract of employment is repudiated or terminated by frustration by operation of law. The parties to the contract cannot repudiate the contract by intentionally or willfully frustrating it. The burden or onus of proof is on the party who alleges frustration of the contract. The equitable maxim, he who asserts must prove, applies in this instance. The frustration of a contract of employment occurs where there is an unforeseen, uncontrollable, or intervening events that the parties experience which affects the terms, conditions, and execution of the contract. And this is referenced in Notcut and Universal Equipment Company, London Limited, 1986. Also in Davis Contractors Limited and Farcham Urban District Council, 1956 case. Conversely, an event that is foreseen and stipulated in the contract of employment cannot be frustrated under the law of contract. And that is referenced in Valella and MFI Furniture Center. It's a 1999 case, and EC Shepherd and Co. Limited and Jerome, and that's a 1986 case.
Okay, so frustration of employment contracts. You think most of the employers could have used frustration in the instance of COVID? Do you think they could have tried using that?
I think they could have tried.
It may have worked, eh? That was an unforeseen circumstance. The contracts were frustrated, so we couldn't continue. Now you may say, oh, well, I've been working for you. I want my pay because by right, I've been made redundant. You weren't made redundant. The whole contract of employment was frustrated. My business have to shut down because of COVID, eh? Is that outside of the control of the parties?
Yes, it is.
Yes, it is.
Yeah, so we may have been able to throw frustration in there. That may be a defense they use next, eh?
Well, what about companies that could have invested in going online and just opted not to?
Well, they could prove that they weren't able, if they could prove they weren't able, it wasn't practicable, then they can say their business still was frustrated, eh? So the ones who really were frustrated were the ones who were shut down, eh? Retail operations, restaurants, hairdressers and all and the like.
Right, okay.
So I can say my, we had a contract of employment, but it's been frustrated. Would I still owe you, you think?
No, because, well, no, that's not your fault.
Yeah, so you think I owe you for the years of service and all that according to employment law?
No.
Yes, you
Well,
should.
unless I continue, if I plan to continue the business, but if I shutting it up, I would say everything is frustrated. There's what happened? What do you call that for frustration? What happened to the subject matter?
It no longer exists.
Yes, there's no job here, so I have nothing to give you. I may try to use that, eh? That
Yes,
could be an argument.
yes, a big one.
Yes. Now, variation of the contract of employment would be used for varying last week. What we talk about? Hello? Hello?
I don't recall what we talked about last week, but I made a note. Could the
No, week
vaccine-
before or
Oh,
something.
week
When we
before.
talk about the buying, say,
Oh,
changing from,
changing the hours, yes.
right.
Oh, yeah,
Can
yeah.
they, yeah, can we unilaterally do that? Can they unilaterally
That
do
was
that?
last week, under the circumstances.
So
No,
what,
they have to have a communication, I think.
if it's not in the contract,
Yeah, they have to have a communication with the parties.
right? And if I have a grievance with it, what I must do? I am an employee. I don't agree with working on Saturday. What I must do?
Put it in writing as soon as possible, but continue to
Yes.
work. Yes.
And then
Okay.
if they continue to carry out, what I must do? 'Cause
File a
I've
grievance.
already- I can file a trade dispute, right?
Yes.
Now, who recently had this issue during COVID period?
The restaurants that tried to mandate the vaccine.
Right, and who else? The big people who gone with the union.
The hotels, eh?
The
Yeah.
nurses, remember the nurses?
Oh, yes, the big thing with the nurses there.
Yeah, they were trying to, they said they had them working under certain conditions. Right. And so they had a big breakdown, eh? They filed a dispute, they gone to the ministry, they had a strike, they were all on Bay Street, the doctors, everybody was out there, eh?
Is that even settled yet?
I doubt it,
I don't
but
think
there
it
was
is.
promises that it will be done, eh?
And that some persons were paid, but I don't think everybody was.
Right, but they got promised, right?
Yeah, yes.
And when
they
I get
went back to work.
promised, what promise gives me? When you promise me something as employer,
An implied benefit.
right? So what we say about the promise? We talked about that earlier,
Yeah, that's what we did.
An intent.
because now y'all will have this language. That's how y'all will be talking when you're talking about. Say it again.
Consideration.
So it's consideration. So when you promise me and I act on it, what happens?
It becomes a contract.
It becomes enforceable, eh?
Right. So I can enforce what you promise you're gonna do. So they promised them they were gonna do, they're gonna pay them, and then they decided, no, we only pay in some instances, remember they promised all the people who work, they were gonna pay, then they decided they could pay certain people only, eh? So
Right.
a lot of things
Exactly.
happen. So we have a lot of clear examples in our own society of these things happening on a daily basis, and it's usually in the news. What about illegal contracts? What we have? Where you knowingly, the parties have to what? Knowingly enter into it, knowing that what? The facts were other than they really were, right?
Right, ambiguous.
So, right, so what it is, I entered into a contract knowing full well I didn't have capacity to enter because I don't have a right to work here unless I have certain approvals.
Correct.
So that's illegally.
Yes, ma'am.
So if we entered into in good faith, what would we have to do? It will not be considered illegal if it was entered into in good faith. And what happened? When you entered in good faith, what you believe? The circumstances to be what?
Certainty of terms.
So it should be true then. It shouldn't be there's nothing that I've not disclosed. So if I've entered into in good faith and you've entered into in good faith, it may not be considered illegal because both of us felt like
You're right.
we were operating within the laws, eh?
Understood.
And likewise with a training or apprentice contract, what happens with that? Do I have to continue with that?
No.
When that's finished, that's it, eh? Do I have to continue with employment with you?
No.
No, because there are provisions which, when I'm finished with the training, that's the end of it. Okay, we've covered a lot of ground in our time. This was a big chapter. So Leslie, we can answer the questions quick and then I'll let you go. What is a contract? We will find that answer.
Page 49.
Page
Page
39.
49,
Page 39.
39, okay. What is a contract?
A contract is an agreement between two or more persons / entities that is enforceable by law, provided certain essential elements exist in the formation of that agreement.
Excellent. What are the elements of a valid contract? Where we'll find that answer?
39.
And what are they?
Offer, acceptance, consideration, legal relation, capacity, and certainty of terms.
Excellent. What is an offer? Where we'll find that answer?
40.
And what is it?
Statement
of terms on which the person making the offerer is willing to be bound.
Okay. What is the legal principle regarding revocation of an offer?
communicate it.
Communicated to the offeree.
Well, find the answer first.
Page 40, number 2.
Okay. Okay, and what is it?
An offer
Okay.
can be revoked at any time. However, the revocation must be communicated to the offeree.
Okay. What are the forms of acceptance? Well, find that.
41.
41.
Page 41. What are the forms?
Acceptance can only happen while the offer is still open.
Right,
Acceptance must be unequivocal.
right,
Acceptance may be by conduct or words, examples, showing up to work,
okay,
returning a lost item, and acceptance must be communicated to the offerer.
okay. What is legally required for an offer of employment? Well, find that.
What do you think?
Say it again. Hello,
That's on page 42.
42. What is legally required? Offer of employment.
I have 46.
46. Mm-hmm. Okay, Arlene, tell me what it is.
Offer
What is
acceptance,
legally required?
The ones,
consideration,
so 1 through 6 points again. Offer acceptance consideration. Is that it?
No,
Okay.
for offer of employment, what's the legal principle? Offer of employment, we have, under offer of employment, which you have? The offer must be made by,
An employee
an
year
employer
to
and individual,
uh-huh,
under contract. of
contract
employment.
employment.
mm-hmm,
No
Must not-
ambiguities or confusion.
mm-hmm,
Unequivocal.
and it must
And
be what?
without-
Fair,
unequivocal.
It must be clearly
fair, and communicated.
and clear intention by the employer to be
True.
bound by the contract, right?
Mhm.
And there should be communicated to the individual to whom the employment offer is being made. How may acceptance be made of an offer of employment?
Expressly or implied. Really?
Excellent.
Or
And we
implied.
will find that.
On page bottom of 46.
Excellent. What are some of the terms, items that may be included in an employment contract? Give me 2, and where I'll find it.
On page 49,
49. Mm-hmm. Give me 2.
the employer's name,
Mm-hmm.
employee's name,
Okay.
the job title, and a brief description.
Okay. Why must the terms of an employment contract be certain?
To prevent ambiguity.
We will find the answer first. Tell me.
Page 48.
Page 48, and what it says?
To avoid ambiguity and any potential legal liability anticipated. Legal responsibility or obligation, the terms must be drafted and represented with clarity and certainty as to the nature.
And why? It's important because,
Underpinning of the framework of the
Right.
employee relationship.
Excellent. Okay. What legal cause of action may an employer or employee take for breach of employment contract? Where we'll find that answer. We will find the answer.
Page 43,
Was it
43.
page 43? Where we find it on page 43?
Yes, page 43.
Uh-huh. What is it for breach of contract of employment for an employer? I mean, what legal cause of action may an employer or employee take for breach of employment contract? What is it? What legal form of action they may take?
Damages,
May
action
take
for an agreement.
damages.
So we have two principles. What are they? The remedies are
Common law. and
under
one
common law.
Equitable. and
Equitable.
principles.
Right. And they can be, so they have, the employer or employee may take for breach they can go for common law or equitable remedies under breach of contract, right?
Yes.
And what are some of the remedies for breach of contract of employment for an employer? Employer is?
Person given the job.
Damages,
They could go for damages. What else?
action for an agreed sum,
Mm-hmm.
or
As much as it's worth. What else?
specific performance,
Mm-hmm.
Injunction,
Mm-hmm.
rectification,
Mm-hmm.
and rescission.
So it could be on either party. It may apply to either one.
Yes.
yes.
Okay.
Either of the parties.
Okay. What are the three main types of contracts of employment? And explain it. What are the three main types?
Page 51.
Mm-hmm.
Permanent employment contract,
Uh-huh.
which is where a permanent employment contract is normally, it comprises of both implied and express terms and should incorporate the statutory and common law contractual terms in the agreement. Temporary fixed-term employment contract.
Mm-hmm.
A temporary or fixed-term employment contract is an agreement between the employer and a temporary worker who is often hired on a fixed-term basis and ends on certain triggers which are drafted to the contract.
Mm-hmm.
And lastly, the training and apprenticeship contract. A contract of apprenticeship is normally an agreement made between the employees and the apprentice where the apprentice agrees to work and be trained by the employer for a specified time, pay, and under certain conditions.
Okay. And the apprenticeship contract, does it have to be continued?
No.
No, ma'am.
Okay. What about number 12? Explain the illegality of employment contracts. Where we'll find that answer?
53.
Page 53.
Page 53. Okay. Mm-hmm. What we saying?
If any of the terms in the contract are considered illegal under law, the contract is considered illegal,
Mm-hmm.
and the rights, duties, and obligations that comprise the terms of the contract
cannot be enforced
by the
by
party,
the party.
by either party.
Right, so once it's illegal, what happens? It's now,
Void. Or
however, what happens with, if they entered into it in good faith?
and it could be considered legal.
That makes it legal.
They could, if they have not, if they didn't knowingly enter into it illegally,
Can be
and
enforced.
it could be rectified, we
considered.
can now continue with it, eh?
Yes.
Okay. So we've had that. Were you able to find any bills or anything going on? Anything else happened? We only have 2 more weeks to go. Anything else happening? Anyone found anything out? Anything happened this week? No? Anything on the table in the house? Yes, no? Yes? Anyone?
No, I don't
I
know.
didn't check.
I didn't hear anything.
Okay, so we're gonna just check to make sure, all right?
Yes, ma'am.
Now, what we need to do is find out a little bit more about, let's confirm the working hours for a part-time employee for our homework, okay?
Okay.
Let's see if we can find out what are the working hours and whether under section 5, anything covers them for their working hours. And then we're gonna look in terms of them being a part-time employee, what terms must be included for part-time, what benefits they have. So we're gonna find out all of that. What are the benefits of part-time employment in the Bahamas? What are their working hours? Okay?
Okay.
And I've sent you some reading material on this chapter. I know it's a big chapter. I hope we've been able to communicate some of the learning objectives. Yes?
Yeah.
It was a little clear, or it's still a little muddy?
It's getting
It's a
clear.
lot, it's a
getting
lot
clear.
of digestion.
Yes.
It's a lot of digestion.
It is a lot. It is a lot.
But hopefully we dissected it enough. So when you read over, it will be a little clearer.
Okay.
Okay? I see they have some more cases, but I'm gonna let you get through what I've sent you, because a lot of these bring out the principles out of these like illegality and all of those things. I've sent you some, but I will see if I can send you about 3 more. Carlisle versus carbolic smoke is a good one as well. So I'll see about sending you that. And Fisher and Bell is the invitation to treat to pull that out a bit more, okay?
All right, ma'am.
Thank you
Okay.
for oh, okay. Now who's that? Who didn't get a case? Which one? Who's that? Sorry. Give me your email address. I'll write it down quickly for you and send you it. Sarah Defoe. Okay, type your email address for me, please. Everyone else got the cases, right?
Yes.
Yes,
Yes,
ma'am.
ma'am.
And y'all want me to send you all the other cases yet, or y'all want to read those at first? Or send all at one time?
I think you just send all and let us go from there.
Yeah,
Okay.
you should send. Let's send it.
Okay, then. I have your email, Mr. Vo. I'll include you on the email as well. Okay, thank you for staying with me today. I know this has been a long class, but you know, we usually get out a little earlier, so we making up for this. We're doing some extra hours for the work week that we didn't work for the full time. So we contravening the law, but this only one time. Yes?
Okay.
We won't
Won't
breach the
take you to court
contract.
today.
Okay, thank you so much. You all enjoy the rest of this nice weekend.
You too.
Okay, you too.
All right,
Okay,
take
Thank
care.
you. Have a good day.
Motion to be true.